Good morning, all. We're here for a hearing in the matter of CFI 027-2018 before Justice Roger Giles. The claimant is represented by Taylor Wessing with the least LLP. The lead counsel is Montago Smith QC. The defendant is represented by Alan Overy LLP. The lead counsel is Yasin Francis.
Your Honour.
Thank you. Two things before I invite Q. Smith to. The first is that I said that I'd give a ruling on the two applications. The registry has been able to get those reasons into the normal form, which is sent to the parties in the email. The copies are available to be given to you now. And when you've had a look at them, we might miss costs. Perhaps we do that first thing tomorrow morning.
Yes, thank you. I'm grateful.
The second thing is thank you for coming at 9:30 time. The reason is that I had to put a short matter in on Wednesday afternoon.
Right.
I'm not too sure how long it's going to take, maybe an hour, maybe a bit more. So what I thought about a bit early today, take stock towards the end of today and decide whether we need to sit any longer hours in order to make sure we get the case through. So an inconvenience anyway.
Not at all. Not on this side anyway. Not.
Well, is there anything else from the parties before Mr. Holmes?
Nothing from me. Nothing from our side.
Thank you. I have read the witness statements, the expert report, of course the judgment of Sir Jeremy Cook. I dipped into the vitals.
Yeah.
I have to say that I don't think that I have familiarity with them.
Understood.
If that's of any help in your opening.
Thank you. And rather than out, will hurry me up if I'm covering ground or well familiar with, or ask me a bit more explanation about the particular issue. So Your Honour will have seen that the claim arises fundamentally out of events which occurred of last year. And what happened then was that the defendant had promised to make certain payments to a third party, AK. Now, AK Global is a party to the action, but it received all of the relief which it was entitled to, so to anything going forward in these proceedings. And my case is that the result of the claim of the defendant failing to make the payments has been very significant indeed. It has suffered considerable losses of that, and those losses fall to be quantified at this trial. Now, in response, the bank says, well, it is owed money, and this is one of the points that I make in my skeleton argument, though. Its counterclaim is put in a very specific way. It is based on a notice of default, which was served on the 8th of June 2018. That notice, the bank says, is what triggers its entitlement to receive certain payments. And the notice alleges, and the pleadings allege, that my client was in breach because it failed to pay a certain sum due on the 26th of February last year. And so the question on that counterclaim is whether my client was in default on the date of that notice on the 8th of June for failing that sum. And, if so, whether the bank can rely on that breach. Because my case in relation to that is any default that there was caused by the bank's contract. And in any event, I say, if one takes the position of that 8th of June last year at least, my client was entitled and is entitled to set off the liability that was being claimed at that stage, which it says, for losses it says it has suffered, arising from the breach of its same contractual.
The set-off does not deny event of planned consequences if indeed there was an event of default, it simply negates the result.
Well, what I say is that it negates the result as at that date, though.
I'm sorry?
As at that date, as at the 8th of June. And so if there is a claim, it can be as at that date. And the question, so the allegation is about 2.2 million was not paid as at the 8th of June. That was the default right, and that's the breach that's pleaded that issue.
So that even if there was money owed as at the 8th of June, which should have been was not,
yes,
you say that there was no event of default because money was also owed, even though yet unquantified.
Right, so it's an equitable set-off.
Okay.
But it is a set-off.
Right.
So that's my second argument, actually, because my first explanation to that is that insofar as it was a breach as a result of failing to pay that money on that date, that failure to pay was caused by that certain breach.
Yes, I entirely understand.
That's the part.
I entirely understand that. To what extent are you going to be submitting that wasn't payable apart from the question of what being caused by
apart from the set-off? I'm not.
Okay.
Yeah. Now, the way the case is put in my own friend's skeleton is he alleges, well, even if my position was right, as at that date, there were other breaches on that day. And so he refers, for example, to a series of documents provided. And also, as a sort of catch-all at the end of his skeleton argument, he said, well, there's a lot of time that has passed, so even if the money wasn't due at that date, a lot of time has passed, and therefore it must in some way. And I say in relation to that, all of those allegations are irrelevant. They are not part of the way that the claim is put to claim. They are not part of the notice that was served. The claim has been put by the defendant in a very specific way, no alternative claim to say, well, all right, if they're right about that, and the money was due on it, well then, even on their own case, these are terms on which the money has been advanced is due back. I accept that that's, in effect, a point about the way in which the claims, and I'll look at Your Honour's reasons for excluding evidence. But what I would say about that is two things. Firstly, well, the pleadings are what the pleadings are. Look at them and decide what's actually said there. But when it comes to issues of case management, one can take a view as to the way the judge approaches it and say, well, there's a range of responses that could be appropriate to that specific question. What I say must be right, though, is that if Your Honour takes a relatively strict approach to issues, for example, on the exclusion of evidence on the basis that, well, these documents were produced for trial, no friend has taken the position that those documents can't. It must be right that this court should take a relatively strict approach also to the way in which parties have decided to put their case. And certainly, that must be if, as I say, where there's allegations to be investigated, there's further allegations to be investigated, affect the way in which the evidence is to be presented. I'll leave that there. Okay. As to the claim that is advanced by the defendant against Mr. Chanana, that is advanced under a guarantee. No points are made as to the validity of the guarantee. Therefore, if Amira, if the claimant owes money to the defendant, then subject to his counterclaim, Mr. Chanana also owes that money. However, he does have this personal counterclaim for losses that he says he has suffered as a result of IDBI's breach. What I was going to do is give you an overview of the background. As I said, if you want to, then please do move me along. But then I was going to turn to look in a bit more detail at the particular claims and what my client says about those claims. So, and as I go, what I'll try and do in a relatively neutral way that you want to identify, it's able to identify where the disputes arise. So everybody accepts that the relationship between the parties started in 2014, and there were these facilities. So the defendant agrees to provide the claimant with certain credit facilities. First, the total limit of those facilities was $8 million. Facility of $3 million for bill discounting and overdraft, and then $5 million for this buyer's credit. So we're going to be hearing quite a lot of buyer's credit. And that started with a sanction letter, which we don't need, I think, to look at. The data that are in the chronology is the 20th of May 2014, and then there was a facility agreement here, which you'll find in tab 2 of bundle D1. And subject to certain conditions, the bank was obliged to extend buyer's credit to the claimant. It's clause 4 of the facility agreement, your 48 of bundle D1. Now, the duration of that agreement at the outset was 12 months. You see that in the debt availability period in the but it could obviously be extended, and this is where there is a degree of disagreement. There is agreement about whether and how the period of the facility extended, the limits of the facility. It may be, as I've said in my skeleton, nothing much turns on this, given the way in which the count. But just so you understand where the dispute arises, if we pick up bundle D1, do that. You will see the original sanction letter behind tab 1. That's the May 2014 document. And then you'll see behind tab 2, the facility agreement itself. And then if you want to go to tab 5, you will see another sanction letter dated 8 March 2016. And I'm afraid my photocopy is not great, but you can see in the table there the existing and proposed limits, and the existing limit is proposed to be increased. Letter of understanding against BC buyer's credit. I'll come back to that. 5 goes up to 7, and the total is 8 goes up to 10. Buyer's credit limit. The overdraft stays the same. The buyer's credit limit goes up from 5 to 8. And then if you turn over the page to page 95, you'll see paragraph 6. The overall limit hereby referred to is subject to periodic review and shall be due for payment by 28th, 2017. Now, the point that's made about this is if you look at the paragraph prior to this, paragraph 5, the bank says, we start in the middle of the third sentence, this sanction letter, the terms and conditions set out herein are acceptable to you. I'll start again. Please note, communication should not be construed as giving rise to any binding obligation on part of IDBI unless you communicate to IDBI within 30 days from the date of receipt. The terms and conditions set out herein are acceptable to you. So it had to be accepted within 30 days. And what the bank says, in fact, reply, is that it wasn't accepted and so never accepted. Now, as I say, it may be that nothing turns on this because as a dispute arises in relation to a sentence from February last year when the buyer's credit was due for repayment, and it is the case that those buyer credits were due to be repaid pursuant to terms of the facility agreement. And I think they do accept that there were subsequent, at least, the duration of the facility agreement, and February 2018 is, of course, really 2 years after this particular letter. It may be Your Honour doesn't need to grapple with that and by flagging it as an area of disputes as we go forward. Now, the case, as I say, relates to these 3 buyer's credits that were due for repayment on the 15th, the 22nd, and 20th of February last year. The total amount of those sums was in approximately 6.4 million euros. Now, the claimant's business is in trade in packaged food and rice, and its main customer on MFC was flour, which is in effect an arm of the Kuwait government. And its main supplier was the actual shipping of the goods, of course, was not going on at DMCC. What was happening, the claimant would arrange rice to be sold from AK Global and shipped to Kuwait flour. And it was part of the contractual chain. So you have a contractual chain of rice being sold, AK Global to Amira selling that to Kuwait flour. And of course, AK Global wants to know it's going to get paid in these trades before it ships. And so on a number of occasions, it requests a letter from the claimant's bank making clear getting paid. And these are what we've always been referring to as the irrevocable letters. And there are a number of these. It appears that there were at least three. First of them was on the 16th of May 2017. And it might just be worth looking at that very briefly so you can see it. It's in bundle D2, tab 19. Bundle 2, tab 19. This is the May 2017 letter, and the crux of it is really paragraph 2. I hope your Honour's had a chance to look at the original one, but if you haven't, it's worth reading paragraph 2, and I'll let you read that yourself.
This is June 2017.
This is May 2017. Do you want to have the same document as me? Bundle D2, tab 19.
Sorry.
Yes, the next one.
Okay. Yes.
So the way the trade is going to be facilitated is the money's going to come in, payments are going to come in from Kuwait Flour IDBI account. IDBI is going to be also going to make payments out, and it's accepted, the bank's witnesses, that in relation to these trades, those payments out were to be facilitated by buyers' credits. And so the position was that, as at this date, Amira was indebted to the bank, so the money comes in, pays down those debts, and then new credit created, buyers' credits are created to make the payments out. That is the mechanism that was being used. So it's not the same, at least in relation to these trades that's coming in and going out. Money goes in, debits, and new buyer's credits issued. Now, the buyer's credits that are issued in practice were not issued by banks, they were issued by corresponding banks, and so the bank had a letter of undertaking to that corresponding bank, in effect guarantee repayment of these buyer's credits. So that's the letter, the irrevocable letter of 2017. It looks like there was also another one in November 2017. Your Honour doesn't have a copy of that in the bundle. There's some reference to it.
Just so I can get a picture, is there in the bundle the buyer's credit with the honouring of the irrevocable letter of the 16th of May?
There are buyer's credits. I don't want to give evidence, since there were certainly the ones that followed this letter. So the connection between buyer's credits and these letters is not, I would say, well established. What I would say, though, is that you have this irrevocable letter. You then have, in the chronology, in September 2017, the buyer's credits that we're dealing with. And then you have a further irrevocable letter in 2017.
So, in fact, at least so far as the bundle shows, the first buyer's credits following 16 of the September ones.
I think whether there are any that have come before, but I think, I'm sure that someone will correct me if that's right, they do come 4 months later. As far as the documents in the bundle code shows, that seems to be right. I can double check that for you and look at it.
Yes, I'd like to understand the toll. That's a little better than I do at the moment.
Understood. All right. In terms of the key chronology for the obligations that you're dealing with today, the next date there was September 2017, and during the course of that, IDBI and the bank arranged the 3 sets, I'll call them, of buyer's credits that were due for, ultimately were due for repayment in 2018. So each was a batch, sometimes 4, sometimes 2 buyer's credit. Those credits were initially due for February 2018, but the dates were extended to February 2018. And in the end, they were due to pay on those 3 dates in February. With interest, those sums are agreed, subject to my set of arguments and all the rest of it. What was due for repayment was on the 15th. You don't necessarily need to take a notice, they are recorded they're recorded in the pleadings as well, but it was just over 2.5 million was due on the 15th of February, so over 1.25 million due on the 22nd of February, and 2.6 million just due on the 20th of February. And that's the one that was said that was not repaid. Now, another area of controversy relates to the terms on which my client contracted with this supplier. You would have seen this reference to the 30,000 metric ton contract. And what I say about this is that in January 2018, the claimant entered into, amongst other things, a contract with AK Global for the supply of 30,000 metric tons of rice. If you still have bundle D2 in front of you, that document is behind tab 42. So you'll see the date of the contract at this page, which is the 9th of January 2018. You'll see on the page 436 of the bundle, so the second page of the document, is quantity 30,000 tonnes. In the middle of the page, quantity, and then on the third page of the document, page 436, you'll see the price, 127.50. My client's case is that this was in effect an umbrella contract. There were 30,000 tonnes which were traded at an in effect an average price of $1,287.50, and so those were to be supplied in various tranches, different tranches of the supply having differences, and there are reasons for that. I won't get into them. You'll hear about evidence. The effect would be that the profit from each And so if you turn forward a tab, you will see there another contract, also 9th of January 2018, between the same parties. And again, on the second page, you'll find a quantity, 10,000 metric tons. And then the price is on the third page, 1378. So this would be a higher price, lower profit tranche, 30,000. There is also one further agreement which you'll find in the third bundle, bundle D3 that is. If your owner has bundle D3, it's tab 139. This comes later in the chronology. This is the 5th of March last year. And so you'll see there that's a contract on page 2 of that document. You'll see the quantity is 8,200 tons, and then over the page the price is 129. Metric ton.
So you've got the specification for the rice the same in all occasions?
No, my friend has some observations about that. So, in relation to each of these contracts, the answer is it's a yes, because a new crop 2060. There are some subsequent contracts replacing the contract, because my case is that this overarching umbrella brought to an end big global as a result of breaches, was placed with contracts. Those specify new crop 2030, new crop 2060. And my learned friend's expert makes some forensic points about that. But I believe that nobody said that there was anything material otherwise in relation to the allegations of the rice, as far as I was aware. So those are the contractual. They've been referred to as execution contracts. Those are the contracts which were to carry, put it like that, or fill the 30,000 metric ton buy contract. There were also some at the 30,000 metric price, and in total 4,900 metric tons of rice was supplied at the 30,000 price, 1,287.50. If you add all those up, they don't add up to 30,000. That there would have been a final slice, and one can work out what the price would have had to be, because the average taken over all of the 30,000 had to be the contract price in the 30,000. And so you get to account for what AK Global had in effect, we say, agreed to the balance of the rice under the 30,000 at. Now, I hesitate to say much more about that at the moment. Many of the documents which Your Honour saw and decided should not be included in this trial did relate to these aspects of the goods. You're going to hear more about it in evidence, in the shape of the dispute. When a friend disagrees with this approach, he says that I should find 10,000 metric ton contract items, so therefore at the lowest profit, at the profit of $20 a ton. That's the shape of that part of the dispute. It's important because it goes to two of my heads of claim, which are firstly the diversion of sales. I'll come on to that in a moment when I deal with it. Profit that my client would have earned on the shipments that ultimately had to go contract directly between supplier and customer. But it's all relevant to my claim, which arises, as I say, from the loss of AK supplier, because having taken the rights of the higher prices, 30,000, we lost the benefit of the rest of the contract, giving Global the excuse to escape the rest of the contract, and the supply at the lower part would have been the much higher parts of that contract. So on the 28th of January, there were to be a series of trades, and so AK Global asked for an irrevocable letter to facilitate those trades. And again, the trades were going to go from AK Global contractually to physically and contractually then to Kuwait Flour. Now, on the same day, the 28th of January 2020, the bank sent an email about the buyer's credits that were due for repayment in February. We can look at that. It's in the same bundle as the one you've got now. We look at tab 71. Got rather a lot of tabs in this case, unfortunately, I have to work with them. So if you turn to page 504, you'll see the email from the bank. The table there is cut off, isn't it? I don't think there's any dispute about numbers, but at the bottom half of this email, you see the bank, Mr. Ashish Kumar Singh, emails amongst others, Mr. Chanana at the Amira, and says, "Dear sir, the following buyer's credits are due for payment in February 2018, and you can group them together. The first two are due on the 15th, and there are two more due on the 15th in line 5. Then there are two due on the 22nd and 4 due on the 26th. And if you go back a page, to place this all in context, you see the response from Mr. Gandhi, hearing from Mr. Gandhi in the course of this trial. "Dear sir," you have that by email. "Shipments to our buyer Kuwait Flour Mills are ready to ship, start coming in 15 days, which will enable us to settle the below buyers, and will pay our supplier with fresh buyer's credits. To get this payment into our account, our supplier has requested a fresh irrevocable letter from your side. Previous letter, copy attached of the same for your perusal. We request you to issue the same at the earliest, and buyers will collect the same." There's then a series of exchanges about documents, and I don't think I need to do those at the moment anyway. Documents are requested and divided, and then if you go back to the beginning of tab 71 on page 500, there's a chase of February from Mr. Gandhi. "As discussed, request you please update for a revocable letter. We need to hand over the same to our supplier." Loaded, and that is the date, the 11th of February, when the irrevocable letter was sent. We ought to just have a quick look at the irrevocable letter that we're actually dealing with. I've shown you the May one from 13. The irrevocable letter itself is in D1 and tab 6. Again, if Your Honour hasn't had a chance to read that, I would just ask you to read paragraphs 2 and 3 in particular.
This is what I looked at.
So there is a difference between the parties and the legal effect place when this letter was issued. So in my case on this, and again, it may be that nothing turns on this, but I let you know what the dispute is. I say that the bank knew the money coming in was going to be paid off buyer's credits. So when the bank promised to pay out, it was promising to extend credit. And it was clear in that context, we say, and we'll cover this more fully, I think, in closing after you've heard the evidence, but give you, it is clear in the context, we say, that the agreement to extend credit was an agreement to extend credit, or arrange buyer's credit, on the terms as before. That would have been the 90 days terms. And the effect, I say, was also necessarily extend the terms of the facility, at least to the date when those would have paid. Now, I don't want to do too much violence to my learned friend's case, and that will tell you where I've got this wrong, but as I understand his position, he says there was no agreement to give any credit, there was no extension of the facility agreements. Certainly there was no agreement to extend finance credit. As you'll have seen, after Sir Jeremy Cook's order, money was paid. When that money was paid back, the bank said we are paying this in a fair way of extending an overdraft. So that is, if the dispute is about terms on the sheets, the bank says overdraft, I say. So that's the 11th of February. So the letters then provided to AK Global, the first shipments are loaded, the money comes in from Flower, and that happens on the 14th of February. And the total is just shy of $4.2 million, because it's 6.9. And so at my client's instructions, it's used to pay off the first two of the buyer's credit, one's due on the 15th and the 22nd of February, and it's also used partially to pay off the buyer's credit due on the 26th of February. But as you see, there's 4.2 coming in and it's 6.4, so there's about 2.2 million or thereabouts left 6th February buyer's credit. However, no money comes out, so the bank does not make the payments to AK Global. It does not issue any fresh buyer's credits. Now, IDBI's case is that there were reasons for this. In particular, it said, the way in which granted buyer's credit to arrangement with correspondent banks by issuing or taking, in effect guaranteeing debts. It says that on the 16th of February 2018, the bank's executive prohibited the issue of fresh buyer's credits as a result of unrelated activity, in particular in the Indian trade market. So there was fraud extended about. As a result, the shutters came said, and the bank stopped letters of undertaking and therefore stopped backing buyer's credit. It may also be the case IDBI had designated or was anticipating designating Claimant as a non-performing asset or non-performing account around that. So all of that we can explore in the course of the evidence. I say legally relevant, even if there was a possibility of supply, of compliance with a contract, at least in the matter of DIFC law, is no excuse. I don't think it's put as a defence to the claim.
I should say that seeing this in the skeletons, I was a little puzzled as to why the reason IDBI was relevant. No doubt that will be further explored, but note that
I understand.
I'm a little puzzled.
Understand. And it may be that some of these areas of dispute, I flagged as to where those take us, and the parties will try to explain their respective positions, but my position is legally irrelevant. It may give you some context.
It may, but the point of my interruption is to encourage both of you not to go into things which really, on further thought, don't matter, legally speaking.
Thank you. Well, in any event, IDBI didn't pay, and the consequences of that, at least in part, have been dealt with in Sir Jeremy Cook in any event. Now, anyone has read that judgment, said I won't therefore take it in detail, but it is important because certain things were decided, and amongst them, I say it was decided that IDBI was controlling payment, was in breach for not making payment, that it was hard to see, although he didn't decide it, the judge said it was hard to see how issuing the irrevocable letter could be understood as anything other than an agreement to extend the facility and to grant credit. And he said the way he put it was, he said, unless it's to be said that the money is due immediately, then it was most likely the solution would be an agreement to extend buyer's credit. Now, you're not bound at those observations are, but he did, as my friend points out, leave over the question, leave open the question, what were the terms of that. You also made the finding that when payments were due, nothing yet was due. Sorry, when the payments came in from Kuwait Flour, nothing yet was due from Mike to the bank on the 15th and the 27th. Those were the dates of buyer's credit, and money came in on the 14th. So the 22nd February buyer's credits paid it off on time. And at paragraph 23 of his judgment, makes the point of the finding, say, that had the bank honoured its obligation, there would have been no question of default by my client in relation to the 26th of February. Why is that? The point there was that these were the first six, a series of transactions intended to be paid through the IDBI account. So had this transaction gone as anticipated, the next few shipments would also have been paid for in precisely the same way. That would have been the payment from Kuwait Flour from the next shipments come in to pay down the rest of the 26th of February buyer's credit payments at the other end. That, I would say, an important finding, finding that the effect of the breach contract by the bank was that my client missed the payments of the 26th buyer's credits. So the impact of all of this was firstly placed my client's contractual obligations. My defendant now seeks divorce. Secondly, because AK Global had stopped shipping, to start the goods shipping again, my client has to agree that the relationship should now be sold, the goods should now be sold direct, and to step out of the transactions. And so the claimant missed out on the profits from those transactions, then eventually it lost the supply contract entirely. I'll come on to that. Now, in the midst of this, while this was all going on, you'll recall that the money came in on the 14th of February. There are then a couple of meetings, we say, that we'll hear about in evidence. But then there is a meeting between the parties on 21st or the 22nd, depending on who's right, of February. And the parties differ about what was said. Now, I may again decide, well, there's not a huge legal relevance in this, but there is a dispute of the facts that happened at that meeting. Claimants witnesses, in fact, they were left with the impression of financial solution coming from the bank. Defendants' witnesses say, well, they have clients that they might be able to explore other options, but it has to be cleared first, and there would be no further buyer's credits. Now, my client says, well, it wasn't told that at the meeting, and in fact, the first heard about this, or at first it got a final decision on this a few days later, on the 24th of February.
Why do you say that might be relevant? If that is, who's right about what was...
I think it might, well, the way in which this happened might well be relevant to the assessment of damages. In particular, my friend's position is that none of this was foreseeable, and so it might have an impact on what could be foreseen. I say there's nothing in the foreseeability, so it could go to that. But I accept that fundamentally there are hard legal questions. What were they breached? And if so, what are the conclusions? So I accept it's unlikely to be at the centre of the case.
We'll see, but this is another area where I was a little puzzled as to why, but no doubt that will all come out in the wash.
I understand, and I'll take that on board. So what happened then is that the 24th they said no buyer's credits. 26th of February, buyer's credits are due, and then on the 27th of February, once the payments passed, the bank issues a letter demanding that payment before. And so IDBI's case is the basis of default, the failure to pay that 26th of February buyer's credit. There were a series of letters to get to this letter on the 6th of June 2018, which is the letter of the event of default. That is the event of default identified the failure to pay that sum. And it's also the basis on which the counterclaims put. And so my say this was caused by IDBI's breach of contracts, and secondly, even if it was due, my client has claims which can be paid. Now, so the court eventually, Jeremy Cook ordered on the 13th of May the payment made by the bank, gave the bank to do that. There was also an issue in relation to certain checks, and I've seen that. The bank was holding certain undated check security, and the bank had threats to enforce, which were interpreted as threats to present. So my client sought, amongst other relief, for Jeremy an injunction to restrain the presentation of the checks. But before we got to court, the bank checks. And they were dishonoured. And what happened in the end was that Sir Jeremy ordered that those checks be passed on by the solicitors. That was an interim order. It's the principle that's final relatively determined in relation to that, but it will obviously turn on what, if anything, is due as between the parties. So I'm going to park that, and that can come later. So the sum was then paid on the 20th of May last year, but even before it was paid, the bank was saying this has immediately, as I said, this is a draft. And so there's this dispute. No draft was then anticipated. Again, nothing may turn on it. So if I can just then deal, I think that's probably enough further background. If I can just the claim and the various heads of claim. The first part of that is, I think, what people have been calling the diverted shipments. We'll get at that later if that's helpful. But effectively, Amira was cut out of the remaining shipment to Kuwait flour. So it lost its profit on those transactions. Totalised it, missed out 17 months. Each shipment was 500 tonnes, so 7,500 tonnes rice. Some of those, I say, would have fallen under 1,000 metric tonne contracts. Some of them fall under the next contract, 8,200 tonnes, and that had a lower purchase price and therefore a higher profit. The total that I claim in relation to that is 303,000. The defendant doesn't accept the profit rate or the number of shipments. It says that most, when confined to the 10,000 contract, that was 20,000 a tonne, most, it says it can establish 6,500 tonnes. So he said, not making any admissions, that most might claim there is $100. The second part of this is then, the second claim is therefore a consequence of determination of contractual relations global, and as a result, my client having to replace the supplier and having to do so at a higher price. The total amount of that claim is put at $2,287,636, and that effectively is the balance of the goods which I said would have had to be supplied by AK Global, but ultimately had to be supplied by two subsequent suppliers, TRO and SR Agro. It was also called Impulse at one point. Now, as to where the profits lie, or where the loss of profits lie, fundamentally, I say, this really comes down to the cost of supply. There are issues as to what was supplied and when and all the rest, but obviously the less that was supplied, the more there was to be supplied at rates. And actually, the sequence in which the goods were to be supplied and the contractual price to each individual shipment had to be supplied, I say, will come out ultimately in the wash. What's critical, Your Honour, is to make findings as to the terms on which this right lies. And I say everything pretty much flows from that. Claimant has produced, however, what's been referred to as sales and purchase matrix. I would like to show you it briefly, just so we can orient you as to what it is and what it shows. And you'll find it in bundle C. I've asked for some A3 copies of certain pages of this because the print is very small. My learned friend, he may have, but he wants to look at it first. To control that. Well, I did promise to show it to him. It's low up of the relevant pages.
I would be encouraged.
Absolutely.
Mr. Francis, let me look at it. A lot of trouble reading the other one.
Your Honour, as long as it's accurate.
Thank you.
It should just be a photocopy. Could you just hand it on? They're not punished. Sorry.
One sec.
Maybe someone can fix it later on. So you should, in the blown up versions, you should see it on the left. It's 44 at an angle, 44 and 45, and then 51 and 52. I will show you, though, just so we can orient in the documents. These are just extracts of 4 pages we've got, but let's go to the documents itself so we can see what it is. If you pick up bundle C, you go to tab 1A, you'll find the matrix. So what you'll see when you see this is that it's broadly in 2 parts. The first part is broadly purchase information, so sales information, and the part is broadly purchase information. It's in 2 parts because of the way it's been printed, so the lines actually continue on. So the second part is a continuation of the. So if you can see the lines, we look first at page 33. Start at 1 and continue down onwards. If you turn then to page 47, you'll see the lines start again at 1 and continue down onwards. So if you viewed this, as I understand it, on a screen, pages 33 to 46 would be to the left of pages 47 onwards. Does that make sense?
I think so.
And then if you turn to page 44, you see the pages that I've had printed out in larger type. And the corresponding part of the sales information is the pages 51 and 52. So 51 and 52 are continuations of the lines that use 44 and 45. And broadly speaking, the first set are about sales information, and the second set is about purchase information from the perspective of Amira, the claimant. And so, what we say, you look at page 44, bits of this information that you need to be aware of start really with line 149. And there are 5 shipments, lines 149 to 153. And those shipments, in terms of supply, were supplied by AK Global at the price that you'll see in the 30,000 contract, and we see that on page 51. So the continuation of lines 149 to 153, you find 51. And if you run across, you'll see the rate. So the cost of mine is 128,750. Do you want to have that?
Yeah.
There's another set at that price, and I'll come on to those in a moment. But those obviously have a relevance to what was left over to supplied on 30,000 contract, because they come out of the supply on 30,000 contract. One of my case is that the final slice, final reach of that contract was to be supplied after the contract has to be calculated, what has been supplied, and then making sure that the average total 30,000 meets that price. So if some have already been sold or purchased at that contractual price, then it affects the final calculation in the final. So then the next set of shipments you'll see at lines 154 to 159, there are 6 shipments there, that's 3 tons of rice. So those are the shipments which were actually delivered and paid through IDBI. Or some of them were paid, yes.
How do we get that? From the date of payment received?
Yeah, you can actually get it from the sales invoice and export reference. I don't think there's any, well, there may be a dispute about that, is it? But if you look at the final column on page 42, you match that to the sales invoices, but in any event, you can see the dates, and the 14th of February is the date of balance payment received, it says.
I was looking at payment received column, which no doubt reflects in some way the sales invoice.
By Amira. So the date of payment received by Amira 14th of February, so you see the date that comes on the 14th of February into Amira's IDBI.
Yeah.
So Amira accepts it's been obviously Kuwait flour for those. So that's the money that did come in to my client. Then they should have been paid out, but wasn't due AK Global. So this is Amira's sales and purchase. So then after those 6, we then have 17 entries that run from line 160 down to 176. And those we say are the 17 convertibles. So those are the sales from which we lost.
I would mind repeating that.
Of course, it's 160 to 176.
Okay.
Those are the 17 diverted sales.
Right. Okay. Yep.
Now, in relation to those, we have sales invoices, at least most of them, but some of them don't because they were amongst the documents. We'll have to explore in evidence that aspect of it, I suppose. And then the final tranche, you can see lines 177 to 181. And again, those are 5 shipments, although one of those shipments was only for 400 tonnes. And if there are questions about that, then the Shanana can deal with them. There was an explanation, but again, that's part of it, it's still excluded. But that's also, those 5 shipments were also at the price in the 30 metric tonne contract. Again, you can see that on this time page 52. Against lines, the same lines, 177 to 181. And so you'll hear reference to the 4,900 tonnes, 30,000 price. Those 4,900 tonnes are, we say, the ones I've just shown you, and then the ones that came at the outset at lines 149 to 15. But if you look at page 52, and you look at, so we've gone down to line 181, which was the final part of the 4,900. Starting at line 182, going down to line 189, you can see that the supplier's name changes. Have that?
Yeah.
And that then becomes Tier Agro. The price goes up to 1,389. And then at lines 190 on. I'm afraid we don't have page 53, it's probably my fault. But anyway, lines 190 on, either the supplier becomes Impulse International, which then SR Agro, which we are the same company. And again, but the price remains the same. 1,389. So, when one looks at the different ways in which the claim are put, in principle there is disagreement between the experts on this. And this is one of the main complaints I have about the way the analysis has found this called. It's not a matter for us to determine what word of terms the parties agreed this price would be supplied. The honour to decide whether there was an agreement at the 30,000 metric tonne for the 30,000 metric tonnes at that price, whether or not my case is correct on the facts as to what was agreed with OK Global Grain for these tranches and the rest. So if the experts confine themselves to their roles, I say, there's very unlikely to be actual disagreement between them. What this part of the claim turns on ultimately is the terms of the supply, and to some extent also what was supplied and when. And so for my reduced margin claim, which is the fundamental question is how much more would they have been obliged to supply and on what terms? And it appears, in fact, everybody seems to agree that if that was the position, then everybody seems to agree that 16,400 in total was delivered if this S&P matrix is accurate, and that would leave 2,600 to be delivered at, we say, the lower price. And that, as I say, that's the experts, in particular the defendant's expert, feels able to draw on the sorts of facts which are really for your honour. And so that is something that you're going to have to police in the course of expert evidence. All right. Now, a good chunk of my learned friend's skeleton is directed at the question of foreseeability. And what he says, in particular, that the loss of that 30,000 contract, he denies that it exists. So if it existed, if there was a loss flowing from that contract being cancelled, he said, well, that is not a loss which was foreseen. And therefore it's too remote, because it's aware of the contract. And it's quite a lot in my own friend's skeleton about that. It's a bit surprising that that date can be quite fairly short, fairly quickly, when one recognises that foreseeability is about foreseeing the type of loss, not the actual loss, which needs to be. So I mean, if we need it, I could extract from Chitty into the bundle, but I would have hoped that would be a trite proposition. Endless common law authority. There is a difference, though, in jurisdiction between DIFC law and the position in other systems of under English law, for example, the question of foreseeability is judged at the date of contracting. Under DIFC law, foreseeability is assessed at the date of breach. And so Your Honour is looking at the question, what could be foreseen, what types of loss could be foreseen as at the date of breach. And I don't understand taking exception to that. That's all I was going to say about the first two parts, and I'll move briefly through the others. The next one, head 3, is a small claim for a discrete loss. The damages claimed there are $35,000. There was a soybean tray, and my client says it was unable to get that. My own friend says, well, how is that caused by my breach? And that will be investigated in evidence. The experts agree that 35,000 headline figure might be reduced slightly to take into account of financing costs. That's a rather minor head of damage. The fourth head, however, is far more significant, and that is the impact, in effect, on the credit reputation of the client of what happened, and the loss in value that we say the business suffered as a result of that breach. Now, my local friend is very dismissive of this. He says, well, I can't establish special damage, I can't show any loss. And one of the reports that were excluded in part was directed at the Trump-Lane. That's not the end of it. I accept this sort of damage is difficult to quantify, and there is evidence out there that losses have been suffered. You will hear from witnesses now that the parent fallen in value, and there's excluded evidence which suggests that fall in value of the parent was the fall in value of the claimant. There is evidence that remains that there has been a significant counter in the claimant's result of these events. As I say, the defendant says, well, this claim isn't sustainable, no evidence of causation. And in response to that, again, these slightly surprising legal submissions, because firstly, there is a presumption of loss that applies in these circumstances. If a bank dishonours a cheque, if a bank fails to pay out on a cheque, the impact of that is that it is presumed that there will be loss, there will be harm suffered as a result of that. And the claimant, in those circumstances, does not need to prove damages. So they don't need to show you that some discrete loss can be tied directly to all of this. Your Honour has the difficult task of assessing general damages in those circumstances, and in any event, I would say, Sir Jeremy Cook has already decided that as a result of the breach, there has been harm to my client's reputation. So, unfortunately, dodged simply because it is difficult to assess. The second point is this. Even if I did have to establish some causative link between the reduction in shares, the fall in share prices, what I say is that that sort of harm is the sort of damage you would expect from this sort of thing. Now, whether or not all of that harm is attributable to these events is a matter for anyone's discretion. But say, in circumstances where a party has established a breach, the kind of damage which flows from that sort of breach, courts are very robust in their approach. In any event, the court will need to consider the evidence and obviously place any value on this part of the loss. Your Honour will hear evidence about that, and I won't say any more about that at this stage. There is then a small claim for lost management time, $14,500. And again, in its skeleton argument, takes a position can't be supported legally. And in fact, you will see, and it's expert this legal position as well, obviously. What it says is, this claim is misconceived because there's an incremental cost to claimants. The claim is for that part of the salary affected individual that wasted as a result of having to deal with this. And my own friend says, well, he was going to incur that, the claimant was going to incur that salary, so legally you can't do that. But that's just wrong in law. It is well established that a cover for salaries for diverted management time is an example of a claim for wasted expenditure. It's a bit surprising that you have that suggestion in my own friend's skeleton argument. And then the final part of the claim is a payment that was made by my client to the defendant in April 2018. The amount that was paid then, again, it's a relatively small figure, $41,000 US. That arose because the bank said, you owe us, you Amira owe the bank amount of interest, pay up. Amira said, we don't owe you any interest, you're in. And paid on interest. And we say that claim for interest has never really been adequately justified, but some explanation as there is shows that that claim for interest of $41,000 was put on basis that the 20th February buyer's credit was outstanding as at that date.
So then conclusion as to whether that money was owed on the 26th of February.
Exactly. And whether or not if it was owed, then it's paid, it's called the same. My learned friend says, actually, there's some other legal response to this. The claim was initially pleaded by my clients as duress. He says, oh, well, that's morphed in my skeleton into intimidation at all. There's a sliver of difference between the two. But in any event, the claim was also restitution. My learned friend says, that's more claim for mistake. Claim for mistake is a head of restitution. And the short point for Your Honour is, if it was demanded and paid that money, then one way or another it needs to be repaid. Restitution is the most likely legal response to it. You don't need to find intimidation. Or either if it doesn't need to be paid back, then it needs to be deducted from the sums that were in fact due at that time. The bank can't just keep it because it's been unjustly enriched at my client's expense. Now, there may be claims where difficult questions arise about whether in this jurisdiction the law takes the English approach, was that there be grounds of restitution on which to pin a claim, or whether on the alternative they take the more liberal approach that other jurisdictions take, some basis approach to restitution. And that there may be claims where that difficult argument needs to be had. This is not going to be one of those claims, one way or another, is demanded by the bank. If it was due, then it goes away. If it was not due, then it needs to be deducted in one way. And then finally, on the claims, there is also this issue of the checks. They're with my friends, with the defence solicitors. We can leave that over until there is also, as I've said, the claim and counterclaim between IDBI and Mr. Chanana, and that terms of whether Amira is liable. Mr. Chanana also has a counterclaim, and again, that is in relation to the diminution value of the shareholding of the parent that was caused by the events in question. The way that works, to understand it, is that some of Mr. Chanana's shares, some of them were pledged. It's the loan that he had taken out with UBS. As the shares fell in value, UBS made a margin call and eventually sold some of those shares. More than 1 million were sold at fair times. Now, the loss, we say, obviously, it is the whole of the reduction in value in the shareholding. However, the value of the shares that were actually sold, and so the loss that was incurred in just discrete which were sold, can also be calculated. Now, again, I recognise the difficulties of evaluating a loss of that sort, but do not award anything. So that is.
And do you claim both the crystallised loss on the sale of shares and a further loss because of diminution in value, or only the former?
Sorry, I missed the question.
Do you claim a loss because of the sale of the pledged shares?
I claim both.
Do you also claim a loss because of a continuing diminution in value of the shares of the parent?
Yes.
Right.
In principle, yes.
Both.
I put in both of us.
Well, they're separate. One is a crystallised loss.
Correct.
The other is different.
Sure. But if one takes it out of this meeting, if somebody damaged my house, loss to me is a diminution in value of my house, whether I sell it or not. If that price recovers, the market forces, then there's a question going to be arised: was that recovery for a collateral benefit from the breach? If it's not to be taken out. My loss remains the reduction in value to me of my assets. And so
my only question was whether you did claim both.
Yes.
And the answer is yes.
Yes, I do. I'm labouring the point. That's the shape of the case. As I said, the issues are largely factual, and there are some legal issues. I say that there are really no genuine expert issues left in this case. We have accounting experts. They're not giving expert evidence as to, for example, methodology for valuing companies. They might have done, but they're not. They're not giving expert evidence as to broken standards. Ultimately, I think what you might have in this sort of case, it might be helpful, is a framework for analysing where all the losses stand. And it may be that your Honour would find it useful for them to head together as often as trial and produce two calculations, one based on one set of assumptions, another. That may be possible for that to happen or alternatively, once your Honour has made some findings to acts. I very much doubt that the parties or the experts would disagree as to that leads to.
Yes, well, there would seem to be too many permutations to realistically list them all.
That might be right.
And if you are right, it might be challenging my mathematical ability with your assistance, perhaps as a result of the fact findings.
That might be right. I'd hope that we could put you in that position now, but as an ability going forward, it may be that if you want to make some factual findings,
yes,
parties can then see
that certainly would be good.
Yeah.
All
right. That's all I had to say. In terms of evidence, you're going to hear from my part from Mr. Gandhi, whose name you will have seen crop up along the way on behalf of the. We're going to hear from Mr. Kumar, Mr. Shri Kumar. So we have 4 witnesses lay witnesses, then we have the experts. We've got a fairly aggressive timetable. We're hoping to get through my witnesses today, witnesses and the expert witnesses tomorrow. Yes, and I'm reminded that Mr. Chinana, who's my first witness, is going to be given
I didn't know.
right. So that's settled. Unless there's anything further I can assist you with at this stage, then that's what I was going to say.
Mr. Francis, do you want to give an opening now or say or keep like what you want to do? It would help me if you gave me an opening.
I would like to give you an opening, sir.
Yes. How long do you think I was proposing to take a 10-minute break sometime during the morning?
I think I'm going to go out for 45 minutes.
45
minutes.
Let's let you go when you've finished. And that means you've got to be pretty accurate.
Thank you, Your Honour. I would like to start by drawing out some of the key differences between the facts that were presented by Amira and AK Global to the bank in February 2018, that were presented by Amira and AK Global in these proceedings since 2019 this year, so about a year after the question. We say this is relevant to the coordination of what alleged loss was foreseeable and what could reasonably have been foreseen by the bank, as at the time it did not make the payment of $4.14 million to AK Global on February 2018. In the bank's submission, this dispenses with the majority of Amira's claims. The significant changes to Amira's story of the proceedings also has an impact on, of course, determining whether Amira has in fact suffered any loss. So those are Amira's claims. I'm not going into detail. I do not propose to dwell on Mr. Chinana's claim in light of the expert report features. The bank's short point on that is that there is zero support for that. It should have been dropped in January 29 when Mr. Chinana submitted an expert report from Mr. Peters that confirmed he has no viable claim. I'll now focus in on Amira's claims, and then I'll make some short submissions on the bank's counterpoint. So, the first question I'd like to address is, how did the facts appear to the bank, the information that was presented to the bank by Amira and AK Global in 2018? I'd like to ask you to pick up bundle D3. And go to tab 71, and it's page 504 in that tab. So we say this story starts on 28th of January. This email here at the bottom of this page, dated 28th of January 2018. It's an email from the bank to Amira, reminding Amira that it has buyer's credits that were due for payment in 2018. Now, if we go to page 503, just across, we've got Amira's response by email on the 1st of February 2018. The response is to say to the bank, payments will start coming in 15 days, which will enable it to settle buyer's credits, pay the supplier with fresh buyer's credits. Amira says that in order to get the payment into Amira's account with IDBI, the supplier has requested that the bank issue a fresh, irrevocable letter. And the email above, on 7th of February, the bank emails Amira and it requests, and this is important, contract copies pertaining to the transaction. It also requested the letter from Amira's supplier. Now, if we go to page 500, so the front of tab 71, we see that the email halfway down the page, 8th of February 2018, 8th of February, Amira emailed the bank, attached the letter from AK Global, and attaching the 9 January 2018 with AK Global. This is the 10,000 metric contract. Amira says, off the back of these documents, request you to provide us irrevocable letter at the earliest. Now, if I can...
Now, I'm sorry, I'm sure that there's no problem with this, but how do we know that that was the $10,000 return contract?
Well, we checked, double-checked and quadruple-checked the electronic version of this email. It was the 10,000 MT contract.
That's...
I'll have to take instructions, I'm sure.
Well,
we can produce the electronic version now.
okay, well, I think that needs to be sorted out.
Yeah, I don't know whether there's an issue.
And simply the request, you place some significance on these. Certainly like to know and see them.
You're right, the case turns on this. Absolutely. These documents were provided by Amira for the purposes of the irrevocable letter. We have the electronic version produced, that's of course the other side.
By all means do that, please, and I'm sure that Mr. Montague Smith is happy.
Yeah, I mean, I know Fred's taken the position that I've copied in further document 2 weeks before trial. Your Honour has decided that is the position. I don't want to be difficult. My instinct, my legal instinct is usually to say the court needs to get to the right answer. But circumstances where evidence has been excluded already, it's a little bit surprising that we're having our evidence on day one of trial. So I don't consent to it, is the position. But Your Honour, no doubt, decide.
Well, I still appreciate your seeing whether you...
Yeah, understood.
Well, Your Honour, this document is in the bundle. It's this email here. Tracks are in the bundle. The letter from AK Global is in the bundle. The document that was sent from Amira, it's their own document. There has been no issue as to what contract was attached to this email very shortly.
The documents are in the bundle. It's simply the question is the link between them. I would have no hesitation of accepting the result of research into the link. To do the research.
If I can take you to bundle D2 and tab 43. Now, this is the 9th of January 2018 contract between Amira and AK Global for 10,000 MT. That's that email that I took you to. If you look over the page, now quantity halfway down, 10,000 metric tons, new crop 2016. We've got period up to March 2018. Over the page, you've got price, 1,378 dollars per metric ton. So, and then if we go to tab 46 in the same bundle, here we have the AK Global letter dated 28 January 2018. This was the AK Global letter that was attached to Amira's email to the bank. As you'll see from the first line, against the current shipment of 10,000 metric tons of rice, we request you to arrange an irrevocable letter for the payment to us. Another link between the email, the 10,000 metric ton contract, and the basis on the bank issued the irrevocable letter. Okay. If I can ask you to pick up bundle D1. to tab 6, just a copy of the irrevocable letter. And the only thing I'd like to draw your Honour's attention to is the line in paragraph 2. The bank is saying, we advise that we are agreeable in principle to facilitate the said transactions. So, we say it's clear the bank is issuing this irrevocable letter in relation to specific transactions which are within its contemplation at this time. Okay, so that deals with the issue of the letter. We'll go through what happened next. You to pick up bundle D3. If we can go to tab 80. Here we have the email at the second half of the page. An email from the bank to Amira stating that it's received 6 payments of $699,000 each from Kuwait Supply Co. That's a total payment of $4.194 million. And you see under the table, the bank is saying, please provide us the letter and invoice / BL copy. So, bill of lading copies up. And we can go to tab 91 in the same bundle. I just want to take you through the documents that were then provided from Amira to the bank. So, it received from Amira 6 inward remittances, and this is an example of one of them. This is relating to the 6th payment in relation to invoice number 148. So you'll see that in the second paragraph. You see towards invoice number, and at the end, 148. I'll ask you to pick up bundle D2. And if we can go to tab 69. Amira also provided corresponding invoices, and here's the example of the invoice, that 6th invoice, number 148. So, what information does the bank have from these documents? Well, you've got a payment of $699,000 for each of the 6 shipments, 500 MT. That's shown on this invoice, at a sale price of 1398 per tonne. So matching the total, if 6 of those, it matches the total amount of the money that's been paid in by payment, so a total of 4.194 million. So this is the evidence of that suggests the purchase price paid per MT metric tonne by Kuwait Supply of Kuwait Power. So they've got the purchase price of the ultimate buyer of the price from this. That's important because we don't have any copy of Amira's contract with Power or Kuwait Supply in the bundle. It was ordered to be produced by Amira. I can take you back to bundle D3. Tab 92. Amira sent the bank also 6 outward remittances. So these requested that the bank make payment to AK Global in the amount of $689,000 per 500 metric ton shipment. So we've got a purchase price here of 1,378 per metric ton, matches the price in the 10,000 metric ton contract that applies to the bank. So the total payment from the 6 shipments requested to be made to AK Global is 4.134 million. So the bank has all the information there to work out that the difference between the purchase price, the ultimate price supplier, Kuwait supplier of Kuwait flour, and the sale price is obviously Amira's profit, which is $20 per metric ton, $10,000 on each shipment of 500 metric ton. So, Amira's profit was supposed to stay in Amira's account with IDBI, and those sums would be available to service Amira's existing debt and any new credit that was extended. And as the payment for 6 of those had already been paid for and were loaded to be delivered to Kuwait flour, the bank would have been able to see that there was 7,000 metric tons remaining to be delivered and paid for under the 10,000 metric ton contract that had been provided with. Now it's very important the bank was not provided with and nor was aware of any other contracts that could have been its non-payment under the irrevocable letter on 14/18. Okay, what happened next? There are a few other facts that are important for context. As a reminder, let's remember that the irrevocable letter request first came from Amira in response to a reminder from the bank that credits were due for repayment in February. Also remember, Amira said on 1st of February 2018 in that email, give us the irrevocable letter and give us further buyer's credit in order to bring in cash to enable Amira to pay the existing buyer's credits. So that was the email that we started off with, the emails between Amira. Okay. It's saying in bundle D3, if I can take you to tab 79. So on 14 February 2018, so it's the same date that the payments have come in from Kuwait Supply, Amira is requesting 6 fresh buyer's credits, $689,000 each, so 4.134 million.
There you go. I apologise, looking for the date. Yep.
So this was the amount that Amira had told the bank paid to AK Global under the 10,000 metric ton contract. Now, just a couple of small points to draw your attention to in relation to these requests. Paragraph 2 on this request: purpose, need, and justification for the proposed credit due to delay in receipt of inward payments. And just over the page 5 to 9, with some other bullet points, we hereby undertake, certify that. And then the second one down, the credit/loan to be raised will be utilised for the purpose for which it is being applied for. And then bottom bullet point, the particulars given above are true and correct to the best of my/our knowledge and belief. I can take you to tab 78 in the same bundle. this is again on 14th February 2018, so the same date that the money came from Kuwait Supply. Amira is instructing the bank to pay down buyer's credits that are due for payment on the end of February. If I can ask you to go to tab 122. You see that under the table, the third paragraph, the paragraph beginning, we have received, you'll see it says, we have received inward remittance of 4.194 million on 14, and against which have requested to settle buyer's credits due on 15 and 22 of February. So there's an instruction from Amira to use the money that's just come in from Kuwait Supply, to pay down two sets of buyer's credit that were due.
We must have the wrong page. What page?
Oh, I'm sorry. It's tab 122 and it's page 602. It should be an Amira letter dated 19th.
That's to pay down the due on 26th of February.
Well, no. Let's go through that. Okay, let's go through it in stages. Okay, so you've got the buyer's credits that are due on 26th of February. They're not saying to pay that down. What they're saying there is shipment to our buyer, Kuwait Supply Co, is at loading stage. Documents will be ready and forwarded to the buyer by the second week of March 2018, for which inward remittance will be received during the third week of March 2018. Hence, we hereby request you to allow us an extension of 30 days to settle the above buyer's credits. They're asking for an extension.
You're referring to the later paragraph.
Yes. The point I wanted to draw your attention to is that they're saying use the money that's coming from Kuwait Supply to not only pay the 15th of February buyer's credits, but also the 22nd of February buyer's credits. And also give us a fresh buyer's credit, 4.134 million, to pay AK Global for the shipments that just been made. Now, we've already covered what information Amira also is giving in respect of 26/2018 buyer's credits in this letter. So
the result of going through these
is Amira was giving the bank a clear impression from this information. They needed three things to enable it to bring in further cash in order to settle the existing buyer's credits. They need an extension of 30 days for the 26th February 2018 buyers, so totaling around 2.59 million, excluding interest and charges. They needed to make the payment by the bank to AK Global under the irrevocable letter, the sum of 4.134 million. They also needed the third thing, which is a fresh buyer's credit of 4.134 million to finance the payment that was being made by the bank under the letter. Now, of course, the bank did not make that payment to AK Global on 14th February or 19th of February. It did not extend the 2018 buyer's credit. It did not grant a fresh buyer's credit. Now, pausing there, I just would like to cover the bank's reasons for why it did not make the payment under the irrevocable letter, and why it didn't arrange a new buyer's credit, and why it didn't extend the 26th February 2018 buyer's credit.
included that, why that matters.
No, I'll start off by saying one thing. I agree with Mr. Montague-Smith. It's not legally relevant. It is relevant for context. I also say it's extremely important for the bank to get its story across to the court. It was not able, it did not have the opportunity to give the full account of the behaviour in making the decisions that it did make in February 15, and it of course placed the order the bank finds it very important to the story, so at least all the facts are before. As I say, legally, we don't think it's relevant. So I'd just like to take you through some documents, but in short, that the bank got a view that was no longer able to arrange credit. And it found itself in a very difficult position.
I witness statement of the general, I can't remember which one it was, who gave this explanation. Is that what you're going to refer to?
No, I was going to take you through some primary documents, but the point is, they felt they were not able to do what they were being asked to do.
That was the message I got from the witness.
Yes. Well, there is some additional context that may become relevant as the witness evidence comes out. So if I could just ask you very quickly to turn to tab 116. I won't dwell since it's not legally relevant.
Okay.
So this is a Reserve Bank of India press release dated 16th of 18, and it concerns a fraud that's been discovered in relation to commitments given by the Punjab National Bank under a letter of undertaking to other banks. And you'll see in paragraph 2 of this press release, it identifies that in that case, paragraph 2, it says it identifies that in that case the fraud was the result of operational risk arising from employee failure of internal controls. And then if we can go to tab 117, we can see the reaction of the bank's head office in India. Most of this is redacted, but if we can go to page 594, the last page, you'll see that the Executive Committee back in India gave very clear directions that no fresh letters of undertaking or letters of credit were to be sanctioned, and any existing letters of undertaking or letters of credit were to be run off. And you'll see that in item number 2 there's a specific instruction in writing that for outstanding letters of undertaking or letters of credit, there was a need to verify the genuineness of the underlying trade transaction and to closely monitor those accounts until closure of letters of undertaking credit. For completeness, and these are the last documents I'll take you through on this legally irrelevant point, and if I can take you to tab 102. There's a series of attempts by the bank to try to arrange a new buyer's credit. So this one is from its 15th of 2018. So it's asking for a quote for buyer's credit in the amount of 2.756 million, which looks very close to the figure of the 26th February 2018 buyer's credit. If we go over the tab, there's another email to the Bank of Baroda thing, and there are a few more of these. I don't think I need to dwell much longer on that. But the point is, the bank tried to do what Amira had asked it to do based on the facts that had been presented to it. That's the factual picture that was given to the bank by Amira and AK Global until the non-payment under the irrevocable letter. Now then, Amira and AK Global made their application to the DIT courts, and it's important to note that the picture that Amira presented to the bank is exactly the same picture that Amira and AK Global presented to the court when they applied for an order to require the bank to pay 4.134 million to AK Global. So they obtained the order, 13th of May 2018. The court also ordered the bank to make an interim payment of costs to Amira and AK Global. Now, if I can ask you just to pick up bundle E and tab 1, just to go to the order with reasons of Mr. Justice Cook. tab 1, page 7, because he neatly summarises the factual picture that was presented to him, and that was presented to the bank here. And it's paragraph 22. And the second sentence, having received 4.194 million, there was some 60,000 in hand if it was made. The effect of the bank's failure to pay its refusal on the 24th of February, some 10 days later, to extend the buyer's credit facilities, a refusal which was repeated subsequently on 27th February, was to prevent AK Global from making further shipments under the 10,000 metric ton contract. There's a typo. It says 10 million there, but that's clearly supposed to reference 10,000 metric tons. Amira, and to prevent Amira from receiving further sums from Kuwait Flour in respect to balance shipments which were to take place thereafter, which would have been utilised to pay off buyer's credit due for repayment. So the bank duly made a payment of 4.134 million to AK Global on 20 May. The bank also paid the interim order on costs. But then let's look at what facts the bank had as at that stage. The bank had seen this contract for 10,000 metric tons, seeing that 3,000 had already been delivered, and that 7,000 metric tons would remain at a profit margin of $20 per metric ton. So that gives a total maximum loss of Amira of 7,000 metric tons times $20, so $140,000 US dollars. And as set out by the bank's expert, Mr. Fitch, the contemporaneous documents provided by Amira in these proceedings only provide some limited for the delivery of 6,500 metric tons. So we say this takes their maximum potential loss down to 130,000 US dollars. Of course, we say that they still have to prove that they did, in fact, suffer some actual loss as a result of our breach. That's the picture presented to the bank, that's the picture presented to the courts. Now, I'd like to go through the facts that have been presented by Amira and AK Global over the course of these. Now, the most significant change in Amira's story is in respect of the basis upon which the irrevocable letter was applied for and granted by the bank. So the bank says, on their own evidence, Amira's and AK Global's own evidence, Amira and AK Global did not present the full picture to the bank when they requested that the irrevocable letter be issued on 8th February 18. And they also didn't present the full picture when subsequent requests were made by Amira for the extension to existing buyer's credits, the applications for fresh buyer's credits. Critically, Amira did not disclose to the bank that the 10,000 metric ton contract presented to it on 8th of February 2018 was part of some wider arrangement between Amira and AK Global under a different contract, 30,000 metric ton contract, which has the same date as the metric ton contract, 9th of January 2018. Now, the 30,000 metric ton contract was not presented in Amira's pleadings to this date. It's not mentioned in Amira's pleadings. It's not mentioned in any of Amira's evidence prior to January 2018. The arrangement between Amira and AK Global in respect of the 30,000 metric ton contract, indeed its very existence, was not disclosed to the bank until 28 January 2019, when mentioned for the very first time in the expert report submitted by Amira. Of course, now, the 30,000 metric ton contract has become the flagship of Amira's evidence, the key document that they rely on to establish the quantum of its lost profit and lost margin claims.
I'm sorry to interrupt. Can I just understand the drift of this? For me, I suppose the point is not so much whether there's a difference in what they said and what they're saying now, but whether what they're saying now is right. Now, this will go to say, accept at all that what they're saying is correct?
I think there are two issues. I think that second issue is an issue to be explored with the witnesses at this trial. What actually were the real facts? What real loss did they actually suffer? What was their real arrangement with AK Global? I think that's one issue.
Well, so that's one reason you're going through these messing with me, isn't it? Because you will be ultimately submitting that, in fact, the only contract in play was the 10,000 metric ton contract.
Well,
or what?
well,
Where are we going?
well, we're going. What was foreseen? What was reasonably foreseeable by the bank? What could have been reasonably foreseen at the time of its non-payments?
I understand that you may say there's unforeseeability.
Yeah. So,
But is there something more?
well, it's about. Well, we need to know a bit more about the actual arrangements between AK Global and Amira to determine whether or not they have some of the loss that they're claiming in these meetings.
I've got whatever the facts I've given, which are much less than Mr. Motley used to like. And that's what's going to answer your question.
I think it's worthwhile focusing in on what Amira and AK Global have now said about their arrangements, and what we're going to cover with the witnesses in the rest of this trial. If I may, I'll take you to the 5th of March 2018 contract. Mr. Montague, Mr. Smith, take you to bundle T3, tab 139. So, this is a contract dated 5th of March 2018. Over the page, the quantity is for 8,000 metric tonnes. So this is a contract that they entered into after the breach. It's a contract that was not disclosed to the bank. And then Amira and AK Global are now presenting that there's some sort of connection with this contract and the 30,000 contract and the 10,000 metric ton contract. They say there's some sort of undocumented balancing arrangement to move monies between Amira and AK Global in order to. So the final position is that between Amira and AK Global, the price actually paid from AK Global is the price fixed in the 30,000 metric ton contract. Now, this arrangement has confused us for ever since we saw Mr. Peters' report in 20 January expert reports. If I can ask you to pick up bundle D4. And it's tab 786. I'm sorry. Tab 197. Page 786. We work out how this 30,000 metric ton contract was relevant to the bank or the irrevocable letter. We couldn't work out how this 8,200 metric ton was relevant to us. We didn't understand this undocumented balancing arrangement. It didn't make any sense to us. But then we have this letter which was submitted very shortly before the trial, 11 July 2019, and this, for the very first time, provides some sort of explanation of...
Hang on. This is the letter which was accepted, wasn't it?
No, I think we...
Or is it not?
No, it's in the bundle. We've agreed to include it in the bundle.
Got it in.
This is the letter from AK Global to Amira dated 11th July 20...
Just so that this is the letter that was in KC4.
Yes.
Yeah, right. Okay,
Yeah.
but that's good.
It's in now, yes.
Okay.
Yeah. So obviously we didn't see this letter until it was produced 11 July 2019, before this trial. So it explains for the first time how the 10,000 metric ton contract is intended by Amira and AK Global to fit by the scheme, the 30,000 metric ton contract.
Didn't explain.
Let me go do the text? Okay.
It's not the first time.
Can I just...
But if you're saying things are inaccurate, I will
Could you respond on this?
No.
I'll hear Mr. Francis.
So you see this third paragraph down. So this is the explanation from AK Global. The purchase agreement was executed in a manner whereby there was a contract for 50,000 metric tonnes for supply to Amira. This contract was executed through partial fulfilment of the 30,000 tonnes and also through separate execution documents which were made as we shipped the product. This structure was due to the different prices that each delivery was invoiced at. This is standard business practice for companies managing their cash flow and bank facilities. It was our understanding that the full 30,000 metric tonne supply would average at $1,287.50 per metric tonne, but that we would supply various volumes, various prices, according to Amira's requests, so that they could hold the majority of the profit with their preferred bank. So then, next paragraph, each shipment was made as and when the product became ready, and the next sentence. The documents were made as the business required them, as the product became ready, and Amira decided which bank they wanted each transaction to go through. The discussions of the structure were done in person and on the phone. So Mr. Montague-Smith may take you to where that explanation was given by Amira previously. We certainly didn't see it. For present purposes, we say it's enough for the bank to submit that the arrangement between UK Global and Amira is highly unusual, that it was not disclosed to the bank in February 2018. And accordingly, the relationship between the 10,000 metric tonne contract and the 30,000 metric tonne contract and other contracts was not foreseen and could not reasonably have been foreseen by the bank as at 14 February 2018. So if the court's with the bank on that point, we say that the bank is not liable for any loss relating to the 1,000 metric tonne contract.
Therefore, foreseeability.
Yes.
Even if Mr. Montague-Smith's quote, story, unquote, I don't mean to, is correct, you say declare no foreseeability.
Yes.
Right.
Now the second point, addressing, I think the second point you were giving on. What are the other implications? One other implication that I would like to flag is that Amira appears to have been in breach of its information representations and warranties in the facilities agreement, as at the date of the irrevocable letter. So if I can ask you to pick up bundle D1. Tab 2, which comes to the facilities.
So begin, please.
Tab 2 and page 56. We're just looking at representations and warranties for 12.1. So, it's your first line. The borrower represents and warrants on each date commencing from the date of this agreement until the final maturity date of that, and over the page, sub-paragraph K, information. The information provided by it to the bank in connection with the finance documents was true, complete, and accurate in all material respects, and is not aware of any material facts or circumstances that have not been disclosed to the bank, and which might, if disclosed, adversely affect the decision of a person considering whether or not to provide it with finance. Now, the definition of finance documents is wide enough to include the irrevocable letter. I take you to that definition, but I don't need to, and unless that's disputed by Mr. Montague.
What isn't hearing it for the first time?
Okay, well, let's go to it, shall we? So, page 42, definition of finance documents. So, finance documents means this agreement, the security documents, any letter of credit or buyer's credit issued, opened, or accepted by the bank, and any other agreement, deed, notice, document, or certificate entered into by the borrower, or any other person pursuant thereto, or otherwise in connection therewith, or otherwise designated as such by the bank and the borrower. So it's as broad as it can possibly be. Now, if we can go to clause 14.1b, on page 62. So look at the events of default. There should be no surprise that any breach of that representation and warranty is an event of default, but let's just track it through so there's no change from the other side. 14.1, each of the following shall constitute an event of default. Misrepresentation. Any representation or statement made by the borrower in any finance document or in any other agreement, letter, certificate, notice, report or statement made pursuant to or in connection with the finance documents shall prove to have been incorrect, untrue or misleading when made or deemed to be repeated in any material respect, as determined by the bank in its absolute discretion. That's an event. So this is the second element. So not the foreseeability, what could have been foreseen. The implication is we say that there's a serious question mark over whether Amira can now rely upon the breach of the irrevocable letter to claim any loss or damage at all, when information that has been provided to us shortly before this trial indicates that they did not present the full picture to the bank when they obtained the irrevocable letter.
I don't follow the reasoning there. Could you explain? I can follow and I might say, well, a failure, therefore there was an event of which may have other questions. But what does that mean? It cannot rely on the failure to pay under the irrevocable letter.
Well, if the bank had been presented with all of the information that it now has, it would have had an impact on its credit. It might have had an impact on its credit decision. And the failure to provide that information means that there was an event of default from the very moment that the letter was issued.
Well, let's assume there was an event of default. Why does that mean that the bank is excused for the irrevocable letter?
No, very good question. So the irrevocable letter, how it operates is payment comes in from Kuwait Flour, and then payment has to be made out to AK Global. There's nothing in the irrevocable letter which requires the bank expressly to provide buyer's credits. Now, if when the money comes in from Kuwait Flour, that money is used to pay down buyer's credits, we're suddenly within the realms of the facilities agreement. And so the issue is, does Amira have a right to insist on the grant of buyer's credits at that stage? So remember, Amira needed three things. The payment to
I'm going to interrupt. The question is, as I understood, you were saying it excused them from payment under the irrevocable letter.
Well,
Is that what you're saying or not?
No, Your Honour. I'm saying
in that case I'm wrong. Let's backtrack.
They were entitled to refuse to grant a fresh buyer's credit. They were entitled to refuse to extend the 26th February 2018 buyer's credit.
All right. Well, we'll come to seeing whether that's right or wrong, but that's the proposition.
Your Honour, yes.
Okay.
Okay, I'll focus now on the specific heads of claim. So I just wanted to give you all the facts as presented to the bank, and now as presented by Amira and AK Global in these proceedings.
I wonder if it might be an idea to have that break now. Would that inconvenience you, Mr. Francis?
No.
We have a 10-minute break now and then go on until 1 o'clock or perhaps a tad after to try and get in a little more time.
When you answer.
Yeah. 10 minutes.
Thank you.
All right.
Thank you, Mr. Francis.
I should just start by saying that we are going to send across the electronic version of that email that Amira sent to the bank on February 2018 with the attachment. So hopefully Mr. Montague will be able to confirm whether or not it has the attachments that we say it has.
Thank you.
I'd also just like to recap before I move on to the lost profits claim. And you asked me about what would have been the implications on the irrevocable letter of only part of the picture having been presented to the bank as at the date it was granted. I just want to make clear that we also say that it may have changed the bank's decision on whether to grant this irrevocable letter at all if they've been presented with two different contracts, the same date, covering the same quantity, with different prices. There would be questions.
So what? You've been held to have been in breach of contract.
Only if that contract was a valid contract.
No, it was a valid contract. It must have been, otherwise the judge wouldn't have held that you were in breach of it.
Well, we have to go back to what information was presented to the court and what information, and it was the same information that was presented to the bank. That is a question. Would the court's decision have been different had they been provided with the information that is now been disclosed in these proceedings?
That strikes me as a very difficult task. You might care to give thought to whether it's worth attempting.
Well, it's not central to our case. It's enough for us to say what was reasonably foreseeable, what could have been reasonably foreseeable, and also the point of whether or not there was an event of default as at the date the irrevocable letter was issued. And certainly when the buyer's credits were being applied for in the course of 14th to 19th of February and the extension to the 26th of February 2019. So I understand your honest point. Okay, let's focus on the lost profits, the lost profit claim. Amira says that it lost profit on certain transactions because, as a result of the bank's failure to make payment under the irrevocable letter, Kuwait Flour or Kuwait Supply made certain direct payments to AK Global. So, if it's entitled to claim any lost profits, it needs to establish with a reasonable degree of certainty that the bank's failure to make payment under the irrevocable letter caused those lost profits. The claim appears to be that AK Global is holding and has refused to repay Amira the profits that Amira would have made on the transactions covered by the direct payments that were made by Kuwait Supply or Kuwait Flour to AK Global. Now, as I've said, the precise arrangements between AK Global and Amira are very unclear. In particular, it's far from clear whether AK Global actually received or held on to any profits that were otherwise payable to Amira. This is something that we want to explore with Amira's witnesses. Based on the contemporaneous records that before the court, there's simply no proof that AK Global did not pay all of the profits that were due to it as a result of their balancing arrangement under the 30,000 metric ton contract. I appreciate proving a negative is very difficult, but there's no record. Two additional points on this head of claim. It's notable, we say, that AK Global has not brought any claim for loss and damage in these proceedings. It's also notable that Amira has not brought any claim against AK Global for the return of any profits that AK Global is not contractually or legally entitled to keep. We've got silence from these two on this point. So we say it's open to the court. A neat shortcut to resolve this issue may be to order AK Global to return to Amira the alleged profits of $303,500 that Amira is today claiming as its lost profits that were paid to AK Global.
We do have pleadings here, you know.
Yeah, wait.
Move on.
Yes. Okay, lost margin. Amira claims that the failure to make payment under the irrevocable letter has resulted in AK Global refusing to conduct further business with it, and that has, as a result, had to enter into other contracts with new suppliers, which provided it with a reduced margin. So, as a first hurdle, Amira has to establish that AK Global cancelled its contracts with Amira due to the bank's failure to make the payment under the irrevocable letter. Now, Mr. Montague-Smith said that the bank's actions gave AK Global the excuse to escape from the 30,000 MT contract, or the excuse to escape from other contracts. The terms of those contracts don't provide any express rights for them to terminate or walk away from those contracts. We also say it's very unusual that after the breach, AK Global entered into the contract with Amira on 5th of March 2018. So this is some 3 weeks after the date for payment under the irrevocable letter, and that payment, of course, was not made by the bank. So I've already taken you to that contract. We say the claim falls at that first hurdle. Leaving that aside, we understand that Amira's argument is that the but-for position, so but for the bank's breach, should be assessed on the basis of the 30,000 metric tonne contract. We say this is a flawed argument, since the contracts which Amira subsequently entered into with TIA Agro and SR Agro are simply not comparable to the 30,000 metric tonne contract. If I can ask you to pick up bundle D2. And tab 42. So this is the 30,000 metric tonne contract. So in the commodity line, you see this is for new crop 2016. And then over the page, you see delivery period, shipment up to March 2018. And then you see over the page again, page 437 at the top, the price of the 30,000 MT contract, $1,287.50 per metric tonne. If we can compare those elements to the contracts which Amira relies upon to establish reduced margin, those are in bundle D4. If you can go to tab 175. So, starting with the commodity, this is for new crop 2017. Whereas the 30,000 metric tonne is for 2016 crop, so last year's crop, the previous year's crop. Over the page, we've got the shipment period. The shipment period is different now. It's a later shipment period, up to September 2018, whereas under the 30,000 MT contract, it's up to March 2018. And of course, the price is different. So on page 716, we've got price for the TIA Agro contract, $1,389 per metric tonne. We go to the SR Agro contract as well, tab 189.
So what was that tab?
Tab 189.
189.
Yes.
Thank you.
Page 750. This is the SR Agro trading contract. You see it's the same story here, same differences. Commodity is for the new crop 2017, not the previous year's crop. And then if we look over the page, the shipment period is different again, up to December 2018. So different from the 30,000 MT contract, a much later period. And the price is the same as the TIA Agro contract that we saw. So page 752, top of the page, $1,389 per metric tonne. Now, there's simply no evidence before the court that AK Global would have offered the same price to Amira as set out in the 30,000 metric ton contract for 2017 crop and for a shipment period up to December 2018. There's also no evidence at all that Kuwait Flour would have paid the same price as it did for the 2017 crop that was delivered under or supplied under the TIA and SR Agro contracts for an older 2016 crop. So we say this claim doesn't get past the second hurdle. Now the third hurdle is that Amira's own evidence, if we believe the facts and figures that are presented by Amira, is that the TIA and SR Agro contracts were more profitable than the AK Global contracts.
Is this Mr. Fritz's report that you're referring to?
It is, Your Honour.
Yes, I remember what he said there.
Okay, so I don't need to cover that. Okay. So the short point is that the highest profit from the preceding contracts, based on information from Amira, is that AK Global's contracts gave them a maximum profit of $110.50 per MT, whereas the apparent profit under the TIA Agro and the TIA and the SR Agro contracts is $160 per metric ton. So we say, look, if you accept Amira's story that the only reason they entered into this contract, these contracts with TIA and SR Agro, is because of our breach, well, we say the additional profits that they made as a result of those contracts should be offset against any lost profits that they're claiming, or any other sums that they're claiming in these proceedings. I'll move on to the lost transaction head of claim. Now, Amira is claiming that it has lost $30,000 in business as a result of not being able to establish a letter of credit for the shipment to a Bangladeshi buyer. If we look at the evidence of Mr. Gandhi and the document that he relies upon for this claim, it's apparent that this claim is based entirely on a single internal email amongst Amira personnel, which only speculates as to the potential profit that could be made on such a transaction. Why don't I take you to this email? It's tab 178. So this is the beginning and end of the contemporaneous documents that support this claim. So the bank's position is it's absolutely plain that there's nothing in this document that would support a claim for $35,000. Moving on to the next head, cost of alternative funding. We had understood from Amira's skeleton argument and from the expert report put in by Amira that this claim had been abandoned.
It hasn't been mentioned by Mr. Montague-Smith, so I take it.
I don't pursue that.
Okay, I won't waste any time on that. Okay, reputation damage. So Amira claims damage to its reputation quantified at over $89.2 million by reference to the drop in the New York Stock Exchange share price of its ultimate parent company, Amphi. Our position on this is very short. The expert evidence that Amira has put in connection with this claim just completely demolishes any prospect of this claim succeeding. In particular, in the expert report, that's just quoted in my skeleton argument, Mr. Peter confirms that he's found no evidence to demonstrate a causal link between the bank's failure to make the payment under the irrevocable letter and the fall in the value of Amphi's share price. I would just pause on this point and say that the bank would like to note that Amira and Mr. Chanana have used this claim in order to significantly delay and complicate these proceedings and drive up the costs of this litigation for the bank. The bank resisted Amira and Mr. Chanana's application to admit expert evidence on the basis that it would be unlikely to assist.
This is not the time to engage in that sort of thing.
I'll move on. Go on. Thank you. Okay, next claim, diverted management time. Amira claims loss of management time as a result of the bank's failure to make the payment under the irrevocable letter, and this claim is based upon a schedule of estimated time that Mr. Gandhi has put together. We say Amira has not demonstrated that it suffered any incremental cost as a result of Mr. Gandhi's work in relation to these proceedings. And we say that there's no contemporaneous records to support the alleged time that Mr. Gandhi spent, which is recorded in that table. Now, moving on to the interest repayment claim. This is Amira's claim for $41,000. Now, it should be clear from our skeleton argument, we're really struggling to work out the basis for this claim and how much court time needs to be spent on this claim in these proceedings. In terms of the facts that I'd like to draw to the court's attention, if I can just take you to bundle D4 and tab 187. Now, this is a letter from Alan and Overy on behalf of the bank, which provides detail of the interest on Amira's accounts, and attaches the details behind this letter. And we had no response at all to this letter from Amira. We also say that it's notable that Amira did not ask its expert, a forensic accountant, to look at this claim, to work out whether or not there was any basis to say that there's something wrong with the interest that's been charged.
But again, isn't it a question for me to decide whether it's right or wrong?
I believe it is wrong.
That's got nothing to do with it.
Well, it's just how it's been pleaded, or how many details we have to respond to this claim. We have put in our response, given them the account statements to show the interest, and we've had no further response from them to explain why they say we're wrong.
Well, in due course, I'll have submissions, and I'll have to decide, presumably, who's right and who's wrong.
Yes, those are Amira's claims, and I'll dealt very shortly with Mr. Chinana's claim. If I may, I'll move on to the bank's counterclaim. And we say the bank's counterclaim is very simple. The bank has advanced money to the borrower, and the borrower needs to repay that money with interest. If the borrower doesn't pay on demand, then the guarantor must pay. So, simple. It may, however, be helpful...
Sorry, pay on demand? Is that right?
Well, the pay when due.
Pay in due. Okay, which does that depend on there being an event of default?
Yes.
Okay.
Yes, Your Honour. I'll take you through...
Pay following appropriate notice of an event of default. Would that be an accurate way of putting it?
Yes, Your Honour.
Okay.
Yeah. Let me take you through some of the documents on this. So, staying with bundle D4 and tab 168. Paragraph 2.1. So this is the bank confirming that it's going to comply with the order to pay the 4.134 million, and it's going to make this payment to AK Global and treat it, insofar as the relationship between the bank and Amira, as an advance under the overdraft facility. Now, it's notable here that previously Amira had asked that if a buyer's credit was not going to be issued, that the money be treated as an extension to its overdraft. And I'll just take you to bundle D3, tab 129.
Yes, thank you.
Tab 129, this is an email from Mr. Gandhi of Amira to the bank, and it's the second paragraph. So this is after we've not paid on the 14th of February under the irrevocable letter, and we've not granted buyer's credits and the extension to the 26th of February buyer's credit that was requested on the 19th of February. And the second paragraph is, request you to get internal approval as a special case to convert our buyer's credit limit into overdraft limit for this time and release the payment by today. So the small point I'm making there is that, okay, we didn't pay, we were ordered to pay, and we're making the payment on 20th of May, but before we make the payment, we say to Amira, okay, we're going to treat this as an advance under the overdraft facility. That's because the bank was still in its position that it could not grant, it could not arrange a buyer's credit, so it could not comply, or at least it believed that it could not arrange a buyer's credit in order to make the advance. So that's the first point on the letter 17th May 2018 from the bank. If we turn over the page to paragraph 2.3, and 2.4, the bank is saying here that even though we're using the framework of the facilities agreement in order to give you this money, so we're treating it as an overdraft, but it says, notwithstanding the above, and without prejudice to the bank's rights, the bank is willing, in the interest of reducing the scope of future disputes, to consider a repayment plan for the advance which is workable for both parties. And then paragraph 2.4, the bank would be willing, on a non-committal basis and without setting any precedent, to consider a repayment plan for the advance on terms which would reflect those applicable to the most recent buyer's credit arranged for the borrower. And then down to paragraph 2.8, the bank invites the borrower to provide its comments on the repayment plan for the advance, as described above, as soon as possible, and in any event, no later than 4 p.m. on Sunday, 20 May 2018. And then over the page, the bank is demanding the repayment of the sums due under the 26 February 2018 buyer's credit. And paragraph 3.3, the bank reserves all its rights in respect of that event of default, including without limitation to apply default interest on the above sums pursuant to clause 9.4 of the facilities agreement, and demand immediate repayment of all outstanding amounts under the facilities agreement pursuant to clause 14.2. That said, the bank would be prepared to consider a waiver of the event of default, provided that the borrower pays the outstanding sums in full within 7 days of the date of this letter, i.e. by Thursday, 24th of May 2018. So, for the avoidance of doubt, next paragraph 3.4, failure by the borrower to make payment on the above sums in full shall constitute an event of default. So we say, whether or not the non-payment on the 26th of February was an event of default as at that date is a moot point and a straw man argument. We're giving Amira the opportunity to negotiate terms and to fix a payment date, or to negotiate a payment date that would be reasonable for it. But in any event, we're reserving our position, saying, look, if we don't have something that's acceptable, we reserve all of our rights. And by this date, by this time, we reserve our right to call an event of default. So, no response was received from Amira, and the bank made the payment to AK Global on 20th of May 2018. If I can take you to tab 171. So this is 21 May 2018, paragraph 2. We have not received a substantive response from the borrower to our first letter dated 17 May 2018, either by the requested timeline of 4 p.m. on 20 May 2018 or at all. In particular, we are yet to receive any comment or proposal from the borrower in respect of a repayment plan for the advance. We should be grateful if you would confirm as soon as possible when the borrower will be in a position to provide a substantive response. Now, if we turn to tab 173, this is a letter dated 24th of May 2018, so this is the date on which the bank had requested payment of the outstanding amounts. Bank wrote again, and paragraph 1.3 here. In our first letter dated 17 May 2018, the bank confirmed that it would be prepared to consider a waiver of that event of default, provided that the borrower pays the amount in full by the end of today, Thursday 24 May 2018. Despite repeated requests, the borrower has failed to confirm whether it intends to pay the amounts in full today. And then we note at the bottom 2.1, in addition, we note that we are yet to receive any comment or proposal from the borrower in respect to a repayment plan for the advance. And then if we turn to tab 174, this is Amira's response from Taylor Wessing. So the first paragraph. The payment should be treated in the same way as it should have been treated on the 14th of February 2018. Of course, we've already offered to do that. We converted it to an overdraft limit in order to pay it, but we've offered them the terms that would have applied to a buyer's credit if it had been granted on the 14th of February 2018. In fact, we're open to giving them, in effect, a much bigger extension of the payment period. And then we have the first statement of Amira's argument, which is pursued to date, and this is in paragraph 2, I think it's the second sentence. The amounts that were not paid on the 26th of February cannot be treated as an event of default, since the event of default was caused by the bank's breach, mentioned at paragraph 1 above. And then over the page, paragraph 3, say demanding repayment is unreasonable on the basis that the amount at hand is still the subject of a dispute between the parties. And then the last sentence, it's almost like the February 2018 emails again. To secure further transactions and contracts, Amira will need a fresh, irrevocable letter from the bank to its suppliers.
Mr. Manager, I understand that all this toing and froing came to nothing. So isn't the question then whether there was the event of default by reason of non-payment on the 26th of February?
I think that's one issue, but we say we don't have to rely on that, provided there has been an event of default at any time after the 26th of February.
Well, you might need, again, to look at the pleadings, because I understand from Mr. Montague-Smith that he holds you quite firmly to them and says that they limit you to an event of default on the 26th of February.
Well, yes, let's look at...
We don't need to resolve this now. All I'm doing is I'm flagging for you for your response in principle, and then we can get to it in due course.
Yes, okay, well, let's have a look. Let's deal with the point briefly now. If we go to bundle A, and we go to tab 7, this is Amira's amended reply and defence to counterclaim. We have on page 37, paragraph 21A, in further breach of the facilities agreement, the defendant has refused to provide further credit facilities to the first defendant under the facilities agreement. And then over the page, paragraph 22, consequences of the defendant's breach. As a result of the defendant's breach, the facilities agreement and or irrevocable letter as aforesaid, the first claimant was unable to repay the 26 February 2018 buyer's credits in full on or before 26 February 2018. Now, if we look at our response to that pleading, which is tab 8, it's our reply to defence to counterclaim. On page 54, paragraph 17, we say that the claimant has failed to provide adequate particulars of its case in paragraph 21 of the reply and defence to counterclaim. And then further, or alternatively, with respect to paragraph 21 of the reply and defence to counterclaim, and then in sub-paragraph D, second sentence, there were multiple breaches of the claimant's obligations under the facilities agreement as at 1 May 2018, which amounted to events of default under clauses 14A, C, D, F, M, S and T of the facilities agreement, including as set out in the following letters. And I can take you to those. Letters.
No, just a minute. What was the reference to that last quote you gave me, please? I haven't caught it. You started with paragraph 18, then...
Sorry, no, paragraph 17.
17.
On page 54. So we're looking at the bank's reply to defence to counterclaim.
Thank you.
Yeah. And then subparagraph D. So we're referring to multiple other events of default on the 1st of May. And then we list those, and then we refer to the defendant's letter to the claimant dated 27th February 2018. And if we look at this letter, it appears in bundle D3.
Well, there's no point in looking at the letter because this is shaping up to be a pleadings argument, I think.
Yes, right. But we list a number of events here that were notified to Amira on 27th February 2018 that were events of default. And then we have a further letter in 2, dated 22nd of April 2018, which again goes through, identifies irregularities with the overdraft. The overdraft is repayable on demand. And then 3, another letter to the claimant dated 1 May 2018, identifying other events of default. And then at the bottom, you'll see it's quoted from the letter, non-compliance of the above requirement is an event of default with the envisaged consequence under the facilities agreement. And we also identify the claimant is also in breach of other provisions.
Well, what I'm saying, I can see an argument coming up as to whether you're entitled to rely on anything other than failure to pay the 26th of February. We'll get to that, but that's plainly, as I think you need to acknowledge, a matter for debate.
Yes, Your Honour, but I think the position is, if we can't establish that we're able to rely upon non-payment on 26th of February as an event of default, we say there were events of default from that date up until we gave the notice of the event of default, of which further notices were given, identifying that event of default. And
yes, but may I suggest you need to give attention to the question of whether you're entitled to rely on them in this case.
Well, if we...
That, as I understand it, is Mr. Montague's position.
Yes.
Maybe that you can't.
Well, if we can't on the basis of our letter in June 2018, certainly we've relied upon events of default by way of our pleadings. in respect of those particular events.
It's a matter of debate. All I'm saying is that I think I recognise myself that there is going to need to be debate over these matters. I understand your position is that you can rely upon subsequent events and default, if necessary.
Yes, Your Honour. And just turning to the notice of the event of default that we actually issued on 6th of June, if we go to bundle D1...
Why are we turning to it?
Just to make sure that I've taken you to it as the final...
That's right.
As the final
I have looked at it. Thank you.
Okay, so our submission there is that the bank has been more than reasonable. It paid AK Global the amount claimed as ordered. It provided Amira with significant extensions for repayment of the amounts that were originally due on the 26th of February 2018. They made repeated efforts to engage with Amira to discuss a repayment plan that would be acceptable to both parties. It's clear that Amira is not going to pay voluntarily, and we hope an order of this court will persuade it to change its position and finally pay the sums that it owes to the bank.
I think an order would do more than persuade it.
My final point is just on the interest calculation, so the interest that's due to the bank. If I can ask you to pick up bundle C and go to the tab.
Is that something that I'm going to be asked to resolve? I'm not aware of any materials that would let me do so, but I may be wrong.
Well, it's just our calculation of the interest that we've, based on the provisions that we've pleaded. So it's just a calculation, just to make sure your Honour has the right number.
Is there a calculation in the papers?
There is.
Ah, that's right.
Yes.
Thank you. I wasn't aware of that.
It was introduced last night, I think.
Yeah. All right.
We understood it was agreed to be included in the bundle. I didn't understand that was controversial. It's a mathematical application, so it's there to assist the court. For your notes, it's bundle C and tab 3D. And with that, Your Honour, that's the conclusion of my submissions in opening.
Thank you. I am not anticipating a responsive.
No, I haven't anticipated a responsive speeches either. My learned friend's opening is rather akin to a closing, though. What would normally anticipate a neutral presentation of the case, identify where the issues are, allow the evidence to happen, and then we can get stuck into submissions at the end. But there we are. But I just wanted to flag one point, which Your Honour has alighted on at the outset, which is that given the way things have fallen out in the run-up to this case, I will be insisting quite strictly and asking Your Honour to insist quite strictly on the pleadings as they have been put forward. That we have heard a number of things for the very first time in my learned friend's opening just now. In particular, this allegation that there might have been some sort of misrepresentation in presenting the request for the irrevocable letter in February of 2018. We've heard some other suggestions, perhaps AK Global wasn't entitled to refuse to supply, perhaps this court could order AK Global to do certain things. None of that, I say, is part of the case. And we will have, as Your Honour has anticipated, a battle on the pleadings, it seems to me, as to whether he can properly rely, firstly, on events that come after the 26th of February, and secondly, if he can take it past the 26th of February, as at the date of the notice that he relies on, the 6th of June, whether he can rely on anything else other than non-payment as at that date of the 26th of February credit.
Yes. I foresee both those.
Yeah.
Anyway, Mr. Francis is duly warned.
There we are.
So, Mr. Chanana, is that the right pronunciation, Chanana?
Chanana. Thank you.
Where's he going? Where is he?
He's in London.
London.
He's in the offices of Taylor Wessing. He was attended by an Anne Overy associate as well, I believe. There will need to be testing of the video link and so forth I wonder whether it might be more convenient to take the hour now.
Yes, that's what I was wondering.
Yeah. And, as long as there's no objection to that, it seems to me to be the right course. Otherwise, we're going to lose 10 minutes while we check the connection, and then have 15 minutes.
Mr. Francis, what's your best guess of the time you'll be with Mr. Chanana?
It's difficult to estimate. I would say at least an hour, but depending on his answers, we might need longer.
Right. Well, it does seem convenient then to take the adjournment now. I assume that he's available enough over in London, but I'll wait around here in case I'm told something to the contrary and we need to rethink. And resume, shall we say we resume at 12:30? Sorry, 1:30?
1:30 is fine for us, yes, thank you.
Yes, sure.
We'll do that. Thank you, Jim.
All rise.
Yes, sir.
Your Honour, I call Mr. Chanana. Before I do, I should make one thing known to you, which is that Mr. Chanana has had a kidney transplant and he's currently on immunosuppressants as a result. The result of that is that there may be moments when he needs to take a short break for reasons that we won't go into.
I understand. Thank you.
Thank you.
And what is the situation about swearing, Mr.
So Mr. Chanana has a copy of the relevant holy book. I believe he has a copy of the oath, and he can be sworn in by an associate, or that can be directed from here through a microphone, whichever you prefer.
Yes. In what? Mr. Chanana, can you hear me and see me?
Yes, Your Honour, I can. Thank you.
Thank you. In what form would you like to be sworn?
I would swear on the Bhagavad Gita. I'd do the oath.
So there's a form of oath in the office, I think it's been sent across.
Yes. Well, I'm not familiar with that way of...
He's referring to the holy book,
yes,
on which he's going to swear. So he's going to swear on the Hindi holy book, and so he'll read out the form of oath which has been supplied by the court.
Oh, it has been supplied?
Yes, and then it's been transmitted. So there should, I hope, be a form of oath there.
Mr. Chanana, you have the form of oath there, do you, which has been provided by the court?
Yes, Your Honour, I do.
And you have the holy book with you?
Yes, Your Honour, I do.
Would you mind taking the holy book and swearing in accordance with the form of oath?
I will do that now. So I swear by the Almighty God to say nothing but the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Chanana. Yes, I'm sorry, I haven't understood it. It's a more unusual form of oath.
Yes, yeah, I think your question is slightly misunderstood. I think.
Yes. I am having a little difficulty in hearing occasionally because of some echoing, but we'll see how we go.
We'll do our best.
Yes.
Thank you.
Please continue, Mr. Montague-Smith. Mr. Chanana, Mr. Montague-Smith will take some formal details from you, and then you'll be asked questions by Mr. Francis. You understand?
I understand, Your Honour. Thank you.
Thank you.
Thank you. Mr. Chanana, you should have a copy of a set of bundles behind you. If you could take up, please, bundle B.
I have that now.
Can you turn, please, to tab 1 of bundle B? Thank you.
Yes, I have.
And first of all, can you please confirm your name for the court and your address?
Yeah, my name is Karane Chanana. My Dubai address is apartment 707. The building name is Al Nabad, Shoreline, Palm Jumeirah.
Thank you. And if I can ask you then to turn... well, first of all, I believe that you have some corrections to make to this witness statement. Is that correct?
That's correct.
Could you
So
tell
there
me
are-
what they are, please?
Yes, please. So, Your Honour, there are 4 points of correction. I am no longer the chairman of the Food Processing and Value Addition Council at the Associated Chamber of Commerce and Industry.
So, sorry, if you just pause there, please, Mr. Shanana. Can I ask you, please, to turn forward to page 2 of your witness statement that's in front of you?
Yes, I have.
And if you look at paragraph 5, is that what you're referring to?
That is correct.
Right, so if you just repeat, so that then reads, I have been the chairman of the board of Amira Nature Foods since April 2012. I'm also the chairman for Food Processing Value Addition Council and the Associate Chambers of Commerce and Industry of India. Can you tell me again what the correction is?
So I'm no longer the chairman of the Food Processing and Value Addition Council of the Associated Chamber of Commerce and Industry of India.
Thank you. And if you could take us to the next paragraph that you want to correct, please.
That's page 8.50, please.
So if you turn forward to page 8, yeah? Is that what you mean?
Correct. If you look at point 50, what I'd like to correct is the total number of transactions were 17, not 13. However, in my first witness statement, I was only aware of 13 transactions because I believe that the balance 4 transactions occurred around the time or after my first witness statement, Your Honor.
Thank you.
Thank you.
Now, if you turn forward to page 10, please.
I have 2 more.
Yeah, I think do they come in this witness statement or in a subsequent witness statement?
In a subsequent one, sorry.
All right, well, let's deal with this one first, please. If you turn forward to page 10, please.
Yes, I have.
Do you see your signature there?
I do.
And can you confirm that, subject to the corrections you've made, that you believe that the facts set out in that witness statement are true?
I believe so. They are
Right,
true.
now, if you turn forward, please, to tab 4. Do you see there your second witness statement? And can you tell me whether there are any corrections you would like to make to this witness statement?
I will just do so if we go to page 32, point 18, 19, please.
Yes?
What I'd like to correct is the replacement contract with TR covered 4,000 metric tons out of the 13,600, sorry. And the remaining 9,600 was supplied by Impulse and SR Agro.
Thank you. Are there any other corrections that you wanted to make in that statement?
There's one more, but I think it may be in the next one.
Can I ask you to turn to page 33, please?
Yes, I'm there.
And if you look at subparagraph B, did you have a correction in relation to that?
Yes, I did. I have said that I was in talks with a potential buyer from Bangladesh, but in matter of fact, I'd like to clarify that the Bangladesh business is handled by my colleagues and the head of sales Manish Tandon and Abhijit Majumdar, who both of whom were in touch directly with the Bangladesh buyer and not me.
I see. And then if I can ask you to turn forward, please, to page 38.
Yes, please.
Do you see there your signature?
I do.
And again, subject to the corrections that you've made, can you confirm that you believe that the facts set out in that witness statement are true?
I do.
Thank you. And then the final statement is at tab 7. Do you see there your third witness statement?
Yes, I do.
And I'm not aware of any corrections, but do you have any corrections to be made on this one?
I don't think so.
Thank you. And if you turn forward to page 63, please. Do you see your signature there?
Yes, I do.
And can you confirm that you believe that the facts set out in that witness statement are true?
I do.
Thank you very much. Your Honour, I do have some short supplementary questions. Would I be permitted to ask those of the witness?
It depends what they are.
Well, they deal with... It depends. I mean, some judges want to hear from the witness's own mouth, having a debate about whether witness statements are of any value at all in England, the central facts of the case. So I was going to ask him about the non-payment of the 26th February credit, briefly, and just ask that particular question. And I wanted to ask him about an explanation of the supply contracts and how they fit together. Those were really the two areas that I wanted to deal with him.
Mr. Francis?
No objection from my side.
Thank you. I take it then.
Yes.
Thank you. Mr. Chanana, I want to ask you briefly about the buyer's credit that was due for repayment on the 26th of February last year. Sorry, because we're doing this through video link, I need confirmation from you that you can hear me when I finish my sentence. So I'll probably wait for a nod or a yes, just to make sure you can hear me. Is that all right? Thank you. All right. Now, some money obviously was paid into the IDBI account on the 14th of February. There's no dispute about that. And that money was used to pay down some of the buyer's credit due on the 26th of February. Can you explain why the rest of that buyer's credit was not paid down?
I can. Your Honour, we got an irrevocable letter from IDBI as usual course of business as we've done previously. The invoicing and the goods were sent to our customer, which is Kuwait. They paid us on 14th of February. Till then it was business as usual. Post that, the buyer's credit was supposed to be paid down as it's been done previously and then freshly issued to pay the supplier. That would have continued business as usual, and the 26th February would have also been paid because the goods were either at port or getting there. Now, due to the failure of IDBI to pay our supplier, he then did not give us the documentation and the process stopped. That's what led to the 26th February not being paid. I believe in the bundles we have evidence of the same being communicated in writing to IDBI as well.
Thank you.
Thank you.
Now, did you want to catch that, or do I need to slow down?
Yes, I did.
I'm grateful, thank you. Now, I then want to ask you briefly about the terms on which Amira was contracting with AK Global for the supply of rice, and I want to show you, if I may, 3 documents and then ask you how those fit together. So the first two documents, in fact, you'll find in bundle D2. So what I'm going to do is show you some documents first and then ask you a question after that. So if you take up bundle D2 and turn to tab 42, please. You see there a contract dated 9th of January 2018. If you turn over the page to page 436, you will see a quantity of 30,000, and over the page from that you will see a price of 1287.50. So that's the first contract that I want to show you. Then the next document I want to show you is behind the next tab, 43. You'll see there a document, a contract dated the same date, 9th of January 2018, and over the page on page 442, you will see a quantity of 10,000 metric tons, and on the next page you will see a different price of 1378. Finally, if you take up bundle D3 and turn please to page tab 139,
Yeah. Yes, please.
do you see there another contract and the date? Do you have the date of 5 March 2018? And over the page, on page 643, in the middle of the page you will see a quantity of 8,200, and then the next page shows a price of 1,289. So can you tell me please, those 3 contracts that I've shown you, how do they relate to one another?
I can. So the 30,000 ton contract, Your Honor, is the master agreement. The balance of the contracts are execution documents. And why is that? We bank with more than one bank. We have facilities in 2 banks, IDBI and Bank of Baroda. And we have a third bank, Mashriq, where we do not have any facilities. As a result, in order to manage our cash flow and our profits, we have execution documents of the master agreement enabling us to manage our cash flow.
And then the final document that I wanted to show you, this. I'm sorry.
No, please continue.
Sorry, so if you look please in bundle D4 and turn to tab 197 at the back.
Sorry, can you repeat the tab, please?
Yeah, it's 197. Do you have there a letter dated the 11th of July 2019?
I do.
Can you tell me how that letter came about? Do you know?
I think this letter from AK Global is addressed to my colleague Devesh and seems to me a clear business letter addressed to us explaining how the business was done.
Yes. I was asking, do you know how the letter came about?
Can you explain your question? What do you mean by that?
Do you know
The letter
how-
came
how
about
AK
to us.
Global-
Sorry, say that again. Apologies for interrupting.
Do you know how AK Global came to write this letter to Mr. Devesh?
Yes, because we've been in discussions with AK Global and other suppliers to secure supply, which is becoming a challenge post February 14th and the happenings of such. And as a result, we've been going back to most of our suppliers and new suppliers to get product. So in the course of business, Devesh, I believe, reached out to AK Global again, as I have in the past as well, to ask them to start business with us again, because it's been some time and they have got their monies finally.
I'll leave it there. Thank you very much, Mr. Chanana. If you wait there, there'll be some further questions for you.
Okay, thank you.
Thank you, Mr. Francis.
Good morning, Mr. Chinana. Good morning in London, where you are. I'm Wessing Francis. I'm going to ask you some questions on the evidence that you provided. First of all, just to confirm, you are the chairman of the parent company of Amira.
That is correct.
You have responsibility for negotiating supply and purchase contracts for Amira.
Correct.
Okay, if I can ask you to pick up or be given bundle D3.
I have it.
We can go to tab 71.
I have it.
And excellent. This is an email from Mr. Gandhi, copied to you, dated 8th of February 2018. And it attaches two documents, or three documents. The first two, AK Global contract copy and request letter from supplier AK Global. Do you see that?
I see the email. Would you like me to go to the documents referred?
Well, let me take you to those documents. If we can pick up bundle D2.
It's here.
Go to tab 46 first, please. See, this is a letter addressed to you from AK Global dated 28th January 2018. You have that?
Yes, please.
It's correct that this is the letter that Mr. Gandhi was referring to in his email to the bank.
I believe so. It seems so.
The first line of the letter. Okay, and the first line of that letter states, against the current shipment of 10,000 metric tons of rice, we request you to arrange an irrevocable letter from IDBI Bank. So my question is, this letter is referring to a transaction between Amira and AK Global for the supply of 10,000 metric tons of rice. That's correct, isn't it?
It refers to the current shipment of 10,000.
Okay, it doesn't refer to any other shipments, does it? Just a shipment of 10,000 metric tons. That's correct, isn't it?
The way business works is the contract which is in place has shipments against the contract. So in my reading, what I believe this states is the current shipment of 10,000 metric tons.
Okay, let's move on to, if you could, in bundle D2, turn to tab 43. This is the contract dated 9 January 2018 between Amira and AK Global. And if you turn over the page, you've got quantity, 10,000 metric tons. This is the contract that was attached to Mr. Gandhi's email to the bank on 8th of February, wasn't it?
If it was, then I would assume that is correct.
You don't know, you were copied into that email. If you don't know, you can say you don't know.
Well, I don't have my email in front of me, but as I can see logically, this is the one, yes.
You think it was the one?
Correct.
Okay. So then the bank issued the irrevocable letter on 11 February 2018, following this exchange of emails. So following the documents that were provided by Mr. Gandhi, the bank then proceeded to issue the irrevocable letter dated 11 February 2018. You didn't provide any other contracts to the bank between the 8th of February email 2018 from Mr. Gandhi to the bank and when they issued the irrevocable letter on the 11th of February? Is that correct?
I believe there was no need to, so that's correct.
Okay. We can just go to your first witness statement, please. Pick up bundle B, tab 1.
Mr. Francis, for clarity, the question was you didn't provide. I take it you were intending to ask whether Amira, anyone in Amira provided. Is that correct?
Correct.
Did you understand the question that way, Mr. Tanana?
Sorry, Your Honour, if the question could be repeated for better clarity.
Yes.
Let me rephrase.
Thank you, Mr. Francis.
Amira did not provide the bank with any other contract other than the 10,000 metric ton contract between Mr. Gandhi's email of 8th of February and when it issued the irrevocable letter on 11th February. That's correct.
Amira gave the execution contract of 10,000 metric tons out of our 30,000 ton contract to IDBI, and I believe it's correct, we did not provide any other contract because this was normal course of business.
So the only contract that the bank had between Amira and AK Global between 8th of February and 11th February 2018, as far as you're aware, is the 10,000 metric ton contract.
Correct. At that time.
Okay. Thank you. We go to your first witness statement, and we go to paragraph 13.
What tab is that, please?
Sorry, B1, tab 1, and then over to page 3, and it's paragraph 13. Yeah, do you have that?
I do.
So you see on paragraph 13, you say, on 9 January 2018, Amira entered into an agreement with AK Global for the shipment of 10,000 metric tons of basmati rice. You see that?
I do. It also states this was similar to previous agreements with AK Global.
Yes. Yeah. But when you're referring to the agreement with AK Global for the shipment of 10,000 metric tons of basmati rice, you're referring to the 10,000 metric tons contract that you provided, that Amira had provided to the bank. Is that correct?
Correct.
Yeah. And that ties up with the document that was actually exhibited to your witness statement there. So page 59, KC1, and we don't need to take you to that, but the number appears in the document that we looked at previously at the bottom of the page. Well, what you didn't mention in this witness statement is any other contract that was related to this 10,000 metric ton contract. That's correct, isn't it?
In order to understand this, you have to understand the question not in isolation. The reason being, there are two aspects to this. One, the business as usual, and then the disrupted business. So under normal course of business, what would have happened is the money would have come in, the facility would have been paid down, redrawn, and it would have gone on like it has previously. Under those circumstances, 10,000 metric ton would have been the only contract provided to IDBI for that moment. So, yes, it's correct.
My question was a bit different. It was, let me ask a more specific question. You did not mention the 30,000 metric ton contract in your first witness statement. That's correct, isn't it?
If it is not in the witness statement, then it is correct.
Well, it's not. It's not in your witness statement. And no doubt, Mr. Montague-Smith will point you to it in redirect if I've made a mistake on that, but it's not.
I also believe that there are experts on both sides, and video from our side has done extensive work on this. And if during in the proceedings, greater emphasis could be put on how the business was done as normal course and what really happened, I think would go a long way in the understanding of what really happened and how our business is conducted. That would be my request if possible.
Thank you, Mr. Chair. Let's just go through some of the facts step by step. If I can ask you to turn to your second witness statement at tab 4, so bundle B, tab 4, page 32, paragraph 16. So this is a witness statement that's dated 21 February 2019.
Can you repeat the paragraph, please?
Paragraph 16, so on page 32. So your witness statement is dated 21 February 2019. Now, this is the first mention in any of your witness statements of a contract for 30,000 MTS dated 9 January 2018. Is that correct?
That's correct.
And you say here it was agreed that the rice would be shipped in parts.
Partial
Yes.
shipment is always allowed, so that's correct.
Yeah. And you provide no other explanation in your witness statement here as to how the 30,000 metric tons contract would operate in relation to any other contracts.
Correct.
Okay. If I can take you to that AK Global letter that Mr. Montague Smith took you to, so let's see where it is. Bundle D4.
Yes, please.
Okay. And I just want you to focus on the third paragraph down. So we'll just start from there and read the rest of the letter from there. So this purchase agreement was executed in a manner whereby there was a contract for 30,000 metric tons for supply to Amira. This contract was executed through partial fulfilment of the 30,000 metric tons and also through separate execution documents which were made as we shipped the product. This structure was due to the different prices that each delivery was invoiced at. This is standard business practice for companies managing their cash flow and bank facilities. It was our understanding that the full 30,000 metric ton supply would average at $1,287.50 per metric ton, but that we would supply various volumes at various prices according to Amira's requests, so they could hold the majority of their profit with their preferred bank. The next paragraph. Each shipment was made as and when the product became ready. The documents were made as the business required them, as the product became ready, and Amira decided which bank they wanted each transaction to go through. The discussions of this structure were done in person and on the phone. Okay, so my question is, do you agree that this letter sets out an accurate description of the arrangement between AK Global and Amira in relation to the 30,000 metric ton contract?
Yes, it does.
Okay. So all discussions of this arrangement were verbal, so there's no record of how this arrangement was supposed to work. Is that correct?
That's correct.
So AK Global would sign different contracts containing prices and quantities that Amira requested. Is that right?
They would sign different execution contracts, and that's correct.
So they would have these different contracts would have different prices and different quantities to the 30,000 metric tons contract. That's correct.
They were all under the umbrella of the 30,000 ton contract and add up to that.
Well, it's not quite my question, Mr. Chinnan. My question is, the contracts that you would execute under the umbrella of the 30,000 metric tons contract would have different price to the 30,000 metric contract and different quantities to the 30,000 metric ton contract. Is that right?
That is correct, but it should add up to the 30,000.
Yeah. And this was done on the basis that Amira and AK Global would arrange any necessary balance payments so that AK Global overall received $1,287.50 per metric ton. Is that correct?
I don't understand the question.
You would agree contracts with different prices and different quantities by comparison to the 30,000 metric ton contract, and then you would make adjustments to the monies received by AK Global on other contracts or other shipments in order to ensure that overall AK Global only received $1,287.50 per metric ton.
That's correct.
And this arrangement between Amira and AK Global was to enable Amira to control where its profits were received and to manage its bank facilities. Is that correct?
That is correct.
So let's just go through this. So some transactions with AK Global would be at a higher price than the 30,000 metric ton contract, like the transaction that was presented to IDBI under the 10,000 metric ton contract. Is that right?
That is correct.
And those transactions would result in lower profit received by Amira. That's correct?
That transaction would have the profit as it's set out in that, correct?
But it would have lower profit than under the 30,000 by comparison to the price under the 30,000 metric ton contract. So AK Global would be overpaid profits under some contracts.
Correct. And as a result, what you said previously, the adjustments would be made in the subsequent or the previous shipments as needed. Because if the pricing, as the pricing is different for different contracts, too, for your better understanding, the subsequent would have been lower. So now, I'm sure that the experts would deal with this better than I have. But from your question, if what IDBI saw was 1378 and had it been business as usual, probably the remaining volumes would have been at around $1,100 odd invoiced for the adjustments which you recognize.
Well, you negotiated the contracts for Amira, so I want to go through how this operated with you.
Sure.
So, okay, we've confirmed. All right, let me ask my question, and I promise I will let you give as full an answer as you want. You've said that some contracts, like the one presented to the bank, would have a higher price for AK Global, which would result in a lower profit margin for Amira. But on the other side, there would be other transactions which would have a lower price than $1,287.50 per metric ton, so lower than the price in the 30,000 metric ton contract, in order to give AK Global a lower payment and to increase the profits received by Amira. Is that correct?
That is correct.
Okay. And so Amira would direct the higher profit transactions to a bank where it could hold those profits safely away from any credit facilities. Is that correct?
That's what we do to manage our cash flow. That's correct.
And to manage your credit facilities, not just cash flow.
Correct. Correct.
So, just to summarise, so Amira's intention through this arrangement was to show low profit transactions to banks where it had credit facilities. Yes?
Amira's intentions were not about showing profit, it was about managing credit facilities to the best of our ability and our cash flow and balancing both.
Let's just focus in on this specific example. For this transaction under the 10,000 metric ton contract, you had a price that was payable to AK Global higher than the 30,000 metric ton price. That's correct, isn't it?
That is correct.
So you were showing to IDBI that this was a low profit transaction for Amira.
That transaction, probably, yes.
Okay. So the 8th February 2018 email from Mr. Gandhi to the bank, which attached the 10,000 metric ton contract and requested the irrevocable letter. Let's just back to that. So the wording of the 10,000 metric ton.
Can you remind me the
Sorry, let me. Okay, if you want it in front of you, it's D3, tab 71. But I really want to take you to the 10,000 metric ton contract itself. So this is, if you have in front of you.
Yeah.
I'm sorry. If you have bundle D2, tab 43. So this is the 10,000 metric ton contract.
I have it, yes, please.
Now, correct me if I'm wrong, but there's nothing in the wording of this 10,000 metric ton contract that indicated any connection with any different contract or the 30,000 metric ton contract. Is that correct?
That's correct. Because these are execution documents.
So,
And the same as we mentioned in the letter, I believe, from AK Global.
yeah. So Amira did not disclose to IDBI at the time of arranging this irrevocable letter that the price in the 10,000 metric ton contract had been agreed between Amira and AK Global at 1378 in order to reduce the amount of Amira's profit that would be paid into its account with IDBI.
Correct?
So it's fair for the bank, based on the information that Amira provided to it and the copy of the contract, for the bank to have understood that this 10,000 metric ton contract was an arm's length standalone contract between Amira and AK Global.
It is still an arm's length and standalone execution document as part of the 30,000 ton contract.
Okay? But from the information that Amira provided, would you agree with me that the bank had no way of knowing that Amira and AK Global intended to enter into other transactions in order to lower the price that AK Global would receive for the same quantity of rice that was delivered under the 10,000 metric ton contract?
I don't understand your question.
Okay, let me move on. Let me move on.
Yeah.
Okay. So let's just focus on the 6 shipments that AK Global was not paid for on 14th of February 2018. So Amira and AK Global had agreed that AK Global would initially be paid more than the price agreed in the 30,000 metric ton contract, because Amira was routing the payment through IDBI.
I think, like I've said previously, and is mentioned in the AK Global letter, we had a 30,000 ton contract and then execution documents. The execution documents presented to IDBI for the credit facility had a $1378 per ton price.
Yeah. Okay. So for these 6 shipments, you were processed, or you intended to process payments through IDBI that would give AK Global $1,378 per metric ton instead of the $1,287.50 per metric ton that was agreed under the 30,000 metric ton contract. That's right, isn't it?
And that is because the balance shipments would have been at probably 1150 or about there, similar to what had been preceding the IDBI shipments, which were around the 30,000 ton contract price and went to Mashriq. So it was business as usual till that time.
So business as usual, as you describe it, was for some contracts, including this contract processed through IDBI, AK Global would in effect be overpaid for those shipments. It's receiving 1378 per metric ton instead of 1287.50 per metric ton. That's correct, isn't it?
At the end of the 30,000 ton contract, IDBI would, AK Global would have seen only 1287.50. The balance is all execution and work in progress. So if you look at it in isolation, yes.
Yeah. Okay. So if you looked at it in isolation, it would tell one story. If you looked at it in the context of other transactions, Amira is getting its real profit back from AK Global through other transactions which are priced at less than 1287.50 per metric ton. That's correct, isn't it?
That is correct.
Okay, so you corrected your first witness statement to say that after the 6 shipments that had been paid for by Kuwait Supply or Kuwait Flour, and after the bank did not make the payment under the irrevocable letter, there were a series of other transactions which were disrupted as a result of the bank's non-payment. So you said these were 17 subsequent transactions, is that right?
Correct.
Okay. Can you pick up bundle D2 and we'll just go to tab 69, please. Okay, so this is the last of the invoices for the 6 shipments that were presented to IDBI in February 2018. And you see that the invoice number here is invoice, just in that first box, under the word commercial invoice, is invoice number 148. Do you see that?
I do.
Yeah, and it's the commercial invoice addressed to Kuwait Supply Co. with notification to Kuwait Flour. You see that?
I do.
So the next 17 shipments, so the next shipment after this invoice 148 should have been a shipment with invoice 149. Is that correct?
I don't know because I don't handle the invoicing or the day-to-day paperwork.
Okay, so you don't know what the next numbered invoice would have been in the sequence.
I don't.
Okay, well, 17 further shipments you say were disrupted. So 17 plus, and these are shipments of 500 metric tons each, yes?
Correct.
So 17 plus the 6 that have already been shipped, that have already been processed through, that Kuwait Flour has already paid for, is 23 shipments in total, isn't it?
If you add this 6 and the 17, I believe mathematically comes to 23.
Yeah. So that's 23 shipments of 500 metric tons, which gives a total metric tonnage of 11,500, doesn't it?
The mathematics seems right, correct.
Yeah. So that's more than the full quantity that was stated in the 10,000 metric ton contract, isn't it?
I think for better understanding, you have to go back to the 30,000 ton contract because the 10,000 ton contract was for IDBI as part of the 30,000 execution document. So there is a 30,000 ton shipment, there is a 10,000 ton execution document. The 17 which you are referred to as part of the 30,000, so hence you cannot compare it to the 10,000 execution document.
Okay, let me just ask another question. So, under the 10,000 metric ton contract, there should obviously only have been delivered 10,000 metric tons in total at the price that had been agreed in the 10,000 metric ton contract. That's correct.
If it was business as usual, absolutely. However, when you mention the 17 shipments, I believe those are the ones which got diverted the payment directly from our customer Kuwait to AK Global because they refused to release the shipments and we were in fear of being blacklisted by our oldest and largest customer. I must tell you, Kuwait is the single largest buyer of Indian basmati rice on the planet. As a result, in order to ensure continuity, we have had to allow our customer to pay our supplier for the first time in our history.
Okay, if I can ask you to pick up your first witness statement, so bundle B, tab 1, page 8, paragraph 51. So this covers just what you were mentioning now.
What's the page?
So what paragraph?
Paragraph 51.
Yeah, I have it.
Yeah. So it says, on 22 April 2018, as a result of IDBI's actions, Amira was forced to agree that Kuwait Flour should pay AK Global directly for these and subsequent transactions. So the date of your agreement for Kuwait Flour to pay AK Global directly was 22 April 2018. Is that correct?
Seems so, yeah.
You think so? Or are you sure?
I'll have to check the letter. I believe there is a letter to our customer asking to pay our supplier directly.
Okay, so you can't quite remember. Let's
in the, I believe it is in the bundle. But
let's have a look at some documents in the bundle. Yeah, if you can pick up bundle D3, and let's go to tab 77. So as you said, I think you said for the first time ever, you were asking a buyer to pay direct to a supplier. So this letter is undated. Kuwait Supply Co. And if you look at the the second paragraph, kindly honour invoice number, and it's 149. Invoice number 149, and is asking for payment direct to AK Global.
That's correct.
Yeah, but it's on the letterhead of Amira Pure Foods Private Limited. That's not the claimant in this case, is it?
No.
No. Okay, we have 13 other of these letters. I'll just take you to examples, and we'll go through them quite quickly. But if you can just turn to tab 95.
Yes.
Here's another letter, again on the headed notepaper of Amira Pure Foods Private Limited, referring to invoice number 150, and signed by you as well. You see that?
I do.
Yeah, okay. And bundle D4, I'll just take you to the last in the sequence that we've got on this. Bundle D4, tab 150. So again,
Yes.
on the letterhead of Amira Pure Foods Private Limited, Kuwait Supply, reference to invoice 161. You see that?
Correct.
So we've got 13 of these letters. So is it correct that you sent these 13 letters to Kuwait Supply, directing them to make the payment as set out in these letters?
Correct, and that's why they paid.
Okay, so you sent them these letters. Okay, great. Let's pick up bundle D3. And if we can go to tab 133.
Yes.
Yep, so you see this letter is dated 22 February 2018. It's on the letterhead of Amira Seafoods International DMCC, which is the claimant in these proceedings.
Correct.
And it's referring to 13 invoices here, this paragraph 2. Kindly honour from invoice 149 to invoice 161. You see that?
I do, yes.
So that duplicates those 13 other letters that you've already sent out under the different letterhead, doesn't it?
Point to note here is that this is 22nd of February and Amira Seafoods, the claimant, is the invoicing party to Kuwait. The parent of Amira C is Amira India. As a result, they are duplicated for the customer so that they have from the claimant and the parent of the claimant.
So let me just see if I understand you correctly. So what you're saying is it's right that the parent of Amira sent 13 letters to Kuwait Supply directing payment direct to AK Global, and it's also correct that Amira, the claimant in these proceedings, sent one letter to Kuwait Supply to repeat the very same instruction. That's what you're saying.
So let me explain better. The claimant Amira Seafoods is supplying to our customer Kuwait. Post 14th of February and the disruption in the business, like I tried to explain previously, the goods were either on their way or at port. To save the contract, the only option left available to us was to allow our customer to pay the supplier directly so that the supplier would release the goods. As part of that process, we wrote, and the claimant wrote this letter asking the customer to pay. Post that, the customer, I presume, would have asked me to have the parent company confirm it, so those were duplicated.
You presume that Kuwait Supply asked for 13 other letters from the parent of Amira. Is that what you're saying?
I did not presume. Kuwait, in my conversation, asked for the parent company to confirm this for their records, and we sent that.
Okay, and you recall that. Is that right?
Yes, correct. Now I'm able to recall the sequence of events and I'm mentioning it.
Okay, thank you. Okay, so we've got 13 invoices covered by these two sets of letters. So 13 shipments of 500 metric tons. So simple maths, 13 times 500, 6,500 metric tons. That's right, isn't it?
For that time, yes.
Yes. And it's covering invoices numbered 149 to 161 in your letter. That's right, isn't it?
As I read it, correct.
Yep. And there's no record of a letter from you to Kuwait Supply requesting that Kuwait Supply make direct payments to AK Global for any invoice numbered from 162 onwards, is there?
I believe there should be.
Well,
The 17
if there
shipments.
is-
Sorry?
Sorry, no, finish. Please finish.
17
Let
shipments.
me-
The 17
I'm
shipments
sorry,
went.
we've got a delay.
Sorry.
Let me ask you a question.
Go ahead.
There's no record in the documents before the court of any letter like this from you on any letterhead to Kuwait Supply asking them to make direct payment to AK Global for any invoice numbers from 162 onwards? Is that?
I can't recall if it is or not, but the fact remains that the payment was made directly to AK Global, and we have evidence of that. If it is not here, then it should have been here.
Okay. Well, if it's there and I'm wrong, Mr. Montague-Smith will no doubt take you to it when we're finished with our questions. But okay, my next question is: there's no record of any corresponding. I'm sorry.
Apologies, Your Honor. As I recall, in my correction, at the time of making the statement, 13 shipments were done. The balance were either on their way or happened subsequently. But I can say, without any doubt, that 17 shipments were paid for directly by our customer to the supplier AK Global.
Okay. There's no record of any correspondence between Amira and Kuwait Supply or Kuwait Flour in response to these instructions for direct payment to be made to AK Global. That's correct, yes?
I believe in the experts would have it. If it's not part of this, it should be part of their statements of reporting, because we have given all documents.
Okay, so the expert, if there is a letter or any response from Kuwait Supply, Kuwait Flour, in response to these letters directing payment direct to AK Global, the expert, your expert, Mr. Peters, should have been provided with that letter. Is that right?
Should be. Otherwise, if the court, Your Honor, will allow, we can provide them now. In the sense, my office in Dubai, Devesh, can get them during the course of this hearing if that's what is allowed.
I think it's too late for that, Mr. Chinar, but let's move on to Kuwait Flour and Kuwait Supply's responses to anything in relation to this case, or any evidence of their conduct. It's right that in the bundle that we have in front of the court, there's no record of any correspondence at all from Kuwait Flour or Kuwait Supply. Isn't that correct?
Kuwait Supply has made its payment on time, and I think and the evidence is with the IDBI receiving the money and AK Global receiving the money directly.
I'm talking about correspondence. I'm talking about emails, letters, messages.
I
don't believe there is.
Question. One moment, please, Mr. Chana. I have difficulty with a question of that kind, because that assumes that Mr. Chana is familiar with what is in the bundles. That is not necessarily a correct assumption.
Okay. Let me
I'll
rephrase.
leave it to you, but it seems to me there's a difficulty.
Okay, let me rephrase the question. So, do you recall Kuwait Flour or Kuwait Supply replying in correspondence to your letters directing them to make payment to AK Global Direct?
There was no reply. They only made the payment on our request.
Okay. And Amira has not produced in these proceedings a copy of any of its contracts with Kuwait Flour or Kuwait Supply. Is that correct, from your recollection?
That is correct, because those contracts are with the Kuwait Supply and Kuwait Flour are government entities, and the contracts carry confidentiality clauses. As a result, have not been provided.
Okay, but there are written contracts between Kuwait Flour or Kuwait Supply and Amira.
Correct.
Okay, and if you had disclosed those contracts in these proceedings, it would give us information about the date of those contracts, yes?
I mean, there's no need to speculate. It's very obvious, yes.
Yeah, and it would also tell us the price agreed for the sale of the rice under those contracts, wouldn't it?
I think the price agreed is very clearly available from our invoicing to Kuwait and evident by the payment received by IDBI.
Yeah, that's all. That's the only evidence we have of the price paid by Kuwait Flour or Kuwait Supply, isn't it?
That is correct.
Yeah. It would also, the contract between Kuwait Flour or Kuwait Supply and Amira would also tell us the quantity of rice to be sold, wouldn't it?
Correct.
it would also tell us the specific crop years for that rice, wouldn't it?
It should. Yes.
Would it also contain delivery timelines for the delivery of the rice?
To my recollection of the contract, it's at the will of the customer, and partial shipments are allowed. It mirrors our contracts with our suppliers. I'd rather say our contracts with our suppliers in terms of shipment mirrors the contract with our customer.
Okay, if we can pick up a different topic, go to bundle D3, tab 122.
Yes, please.
So this is your letter to IDBI, dated 19 February 2018. So signed by you, and under the table in this letter it says, shipment to our buyer, Kuwait Supply Co, is at loading stage. The documents will be ready and forwarded to buyer by second week March 2018, for which inward remittance will be received during third week of March 2018. Hence, we hereby request you to allow us extension of 30 days to settle the above buyer's credit.
Correct.
You also, also the third paragraph under the table, you request that the bank release the payment of 4.134 million to pay AK Global, and you say the last sentence there, the delay in releasing payment will result in delay in next shipments, so next shipments, which will create issue with our buyer, which is a government entity. You see that?
I do.
So, for the next shipments, what you were expecting, or what you were telling the bank to expect, was that payments would come in from Kuwait Flour for the next shipments if they issued this buyer's credit of 4.134 million. Is that right?
Correct, because that's what's been happening always, and the bank has history of that. Correct.
Yeah. And then Amira would then present the next invoices in the sequence to the bank. Is that correct?
As it happens, yes.
So, following the sequence we followed up to date, it would be the next invoices in the sequence would be numbered from 149 onwards. Correct?
I can't tie up the assumption of the invoice numbers. Like I said, I don't handle invoicing.
Okay, but for the very next shipments that are due from AK Global, you're telling the bank here in this letter that these shipments are going to be processed through the bank. Is that correct?
Correct, because that's correct, yeah.
Okay, so staying in bundle D3, if we can go to tab 74.
Yeah.
Yeah, you see that? Okay, so this is Amira's commercial invoice addressed to Kuwait Supply in the amount of $699,000 US. It's dated 12th of February 2018. Do you see that? At the top?
Yes, I do, yeah. Yes, please.
So that's before the shipments, or before the payments had been received by the bank for the 6 shipments on the 14th of February 2018. This invoice predates that, doesn't it?
It does.
Yes. And there's something very unusual about this invoice.
Please tell
Because
me.
if you look down at the payment instructions, it's directing payment from Kuwait Supply or Kuwait Flour Mills to Amira's Mashrek Bank, isn't it?
Correct.
So what it's not doing is requesting Kuwait Supply to pay for the next shipment to Amira's bank account with IDBI. It's not doing that, is it?
In this, no.
Yeah. And I think you confirmed in your answers to Mr. Montague Smith's questions that the Mashrek bank account doesn't have any credit facilities.
Correct.
Okay. So the Mashrek bank account is where Amira prefers to hold its profits on these transactions.
Correct.
Correct. Okay. Okay.
So what's
we have
unusual?
other commercial. I'm sorry. Please go ahead.
No, you said there's something unusual. What's unusual?
Well, the thing that's unusual is you're telling the bank that you need the buyer's credits to be issued for 4.134 to allow the next shipments to come through to enable that money to be used to pay down the buyer's credits, but you have already issued an invoice before 19th of February 2019, so invoice 149, which is directing payment for the next shipments not to IDBI's bank account, not your Amira's bank account with IDBI, but to your other bank account, Amira's other bank account with Mashrek Bank. That's what's unusual.
Well, your assumption is incorrect here because you're assuming that these are the next shipments. These are shipments which are already in process, whereas in the letter which you took me to previously it stated that the shipments are under loading. So your assumption that these would be the next shipments, whether they've already been invoiced, is potentially incorrect.
Well, you already confirmed to me that the very next shipments from AK Global were going to be processed through IDBI Bank. That's what you said.
Well, this is where I say the assumption is incorrect, that very next to what? We are saying these are under loading. It's an ongoing process. These are physical goods which are in the process of shipments and they're shipped in bits of 500 tons each.
Okay, well,
So
before I
that's why
get
I
to
say,
this invoice,
if you look at, if I may, that's why I said, if you look at the 30,000 ton contract in its whole execution cycle rather than isolated exclusions, it actually makes for the correct picture. That's all.
Well, you gave me an answer to my previous question, and now you're changing your answer after you've been
I'm not
presented with this
changing an
invoice.
answer, I'm attempting to, I'm sorry, I'm not changing my answer, I'm attempting to explain better, that's all.
Okay. Well, let's move on. There are other invoices like this. So if I can just take you to tab 93.
Yes, please.
Invoice dated 14th of February. Invoice number 150. Exactly the same. Payment is directed to Mashrek, not IDBI. You see that?
Correct. Now, as I recall, these are the ones where the payment had to eventually go to AK Global because they did not release the goods to the customer, and these were not the next shipments then. So why I keep going back to the total 30,000 tons is what happens. These were lying at port. 22nd February, you just showed me a letter where we asked Kuwait to pay AK Global directly because these were obviously sitting at the Kuwait port or about there at that time. Now, why did that happen? Because after 14th of Feb and up to 22nd February, it was becoming more obvious that our business is disrupted. So your assumption the next shipments would be what is under loading and not 149, 150.
Okay, we've got your two answers on that. That's fine. Let's turn to tab 96. There's another one of these invoices. This one dated 14th of February again. Again, payment directed to Mashrek, not IDBI. See it? Let's go to 99. Tab 99. Here's another one, another invoice. This one, invoice number 152, dated 14th of February 2018. Again, to Mashrek. Do you see that?
I see that, and look at this in the context of what the 17 shipments, potentially this would all add up to the 30,000 tons, 100%. So, looking at it in isolation again is misleading.
Okay, looking at documents in isolation is misleading. I agree with you on that. Let's go to tab 106. Commercial invoice dated 15th of February 2018. Again, payment directed to Mashrek, invoice number 153.
Correct.
Yeah, let's go to 109. Another one, invoice number 154, dated 15th February 2018, Mashrek Bank. Let's go to tab 112. Another one, this one dated 15th February 2018, invoice number 155. Let's go to tab 118. This one's dated 17 February 2018, invoice number 156. It's the same, payments directed to Mashrek Bank again. Okay, tab 123. Now this one's dated 19 February 2018. So the same date as that letter that we saw right at the start to the bank, whereby you said the next shipments are going to result in payments coming through IDBI that would pay down the buyer's credit. 19 February 2018, invoice 157. Okay, and there's another one, 126, invoice number 158. Again, dated 19 February 2018. Directed payment to Mashrek Bank. And all of these are for shipments of 500 metric tons. So we've got 10 shipments of 500 metric tons which are covered by these 10 invoices that we've just gone through. So it's correct that you were telling Kuwait Supply or Kuwait Flour to pay 6.99 million to Amira's Mashrek bank account. Is that correct?
So, and these are all dated February 19th, and my letter to IDBI states the next shipments which are next after 19th February, which says they'll be loading in March. So these are previous shipments, not next shipments.
Well, we can possibly come back to that. That's not what that letter says. Your letter says next shipments,
interpretation.
And it says payments are expected back through IDBI in the 3rd week of March.
Correct. So these are shipments which are already done. Those are shipments which are under loading, and that's being very clear in my letter.
We're going over the same ground. That wasn't even my question. My question was, as a result of these 10 invoices, you're directing Kuwait Supply or Kuwait Flour to pay $6.99 million to Amira's bank account with Mashrek. That's correct, isn't it?
Now that you restrict the question to that, it's correct.
Well, that was my question. Okay, so you said Kuwait Flour, Kuwait Supply, this is a government entity, yes?
Correct.
So you've issued these invoices to them, telling them to pay your Mashrek bank account, and then you've issued them with 13 undated letters from a different Amira entity. You've issued them with one letter dated 22 February saying direct the payments for invoices to AK Global directly. That's correct, yes? There's no response. Or did Kuwait Flour or Kuwait Supply ask you to reissue any of these 10 invoices that we've just looked at?
So I think I need to explain here how business is actually done. Invoices form part.
If you answer my question first, and then you can explain. Did Kuwait Flour or Kuwait Supply ask for any of these invoices to be reissued?
Invoices are issued for the purpose of shipment, custom clearance, and payment. The invoices go alongside the process of business and shipment. After receiving the goods and the paperwork is the payment made. Now, it's important here for me to come in and explain and as a result answer the question. These invoices 17 which you have highlighted, the documentation did not get to the customer. Why? Because the supplier AK Global didn't release it. The goods were at port. Had the 14th February payment which came into IDBI been made to AK Global, these documents would have been released. However, the supplier AK Global held back the documents and only agreed to make them available if they were paid directly. That is why on 22nd of February we sent that letter to Kuwait in order to make sure our relationship was not harmed or we were not blacklisted, because they needed the goods and the goods were at port. Subsequent to that, on their verbal request, the parent company issued the 13 and 17, the total of 17 letters, 13 of which are here, and you've shown me, confirming as a confirmatory. So that's the sequence of events.
Okay, let me just try and unpack some of what you've said there. So, were these 10 invoices that we've just looked at, were they sent to Kuwait Supply or Kuwait Flour?
Kuwait Flour is the parent of Kuwait Supply.
Were these invoices that we've just looked at, were they sent from Amira to Kuwait Flour or Kuwait Supply? It's a very simple question.
They were sent to their bank, and the bank only releases it when the supplier will release the bills of lading. That's why the process of business needs to be understood.
So these 10 invoices were sent directly to Kuwait Flour or Kuwait Supply's bank. That's what you're saying?
I believe it was sent as part of routine business. I will have my office confirm, if need be, exactly where they sent it. But please understand.
You just said that they were sent. You just said that they were sent to Kuwait Flour's or Kuwait Supply's bank. So, what, you're not sure now?
It's very simple. As part of business, documents are not sent in isolation. Invoice is along with shipping documents. When the shipping documents did not get released, these eventually would have only got to them after AK Global gave us the bill of lading.
Okay, let's move on. So for these 10 invoices and these 10 shipments, so invoices 149 to 158, it was never intended that the 6.99 million that was going to come from these shipments would be paid to Amira's bank account with IDBI. That's correct, isn't it?
These shipments were going to come into Mashriq as the invoice states, had it been normal course of business.
Yeah, these payments were not going to go to IDBI Bank, were they?
No. And these are predating our request to IDBI.
Well, they're not, because we've gone through the dates, but let's not go over them again. If we can pick up bundle D4. And if we can go to tab 142, please. Yeah, so this is the next commercial invoice in the series of invoices that we've been following. Okay, so this one is numbered 159. You see that at the top. The date is 22 March 2018. You see that?
Yeah, I do.
Yeah, and that instructs direct payment from Kuwait Flour or Kuwait Supply to AK Global. Do you see that?
I do.
Yeah. Okay. There are two other commercial invoices like that. So let's very quickly look at those. Tab 145. Commercial invoice number 160, dated 5th of April 2018. So exactly the same, direct and indirect payments. And then the only other one of these that we've got is at tab 148. Again, dated 6th of April, invoice 161. So these are 3 invoices covering 3 shipments, 3 payments of $699,000 US.
Correct.
Now, is it correct that there are no other invoices which directed payment direct from Kuwait Flour or Kuwait Supply to AK Global?
I believe there are 17 in total.
Okay. We haven't seen any others. These are the only 3 that we've seen. And if I'm wrong on that, Mr. Montague Smith will take you to that in the bundle.
Well,
Okay, if we can go to your witness statement, bundle B, tab 1. Page 8.
Sorry, what page?
Page 8.
Yes.
That's your first witness statement, paragraph 51.
Yeah, go on.
Here it says the second sentence. Sorry, do you have that? Okay, it says AK Global has accepted a provisional undertaking from us that Kuwait Flour will continue to pay AK Global directly. Do you see that?
Yes.
Yeah. Did you make a record of that undertaking, that provisional undertaking that Amira provided to AK Global?
What do you mean by that? I'm sorry, I don't understand.
Did you put that provisional undertaking that you describe here in writing? Is there any record that exists of this provisional undertaking?
It should. Not.
Okay, but you didn't exhibit any record to your witness statement to show this provisional undertaking. Did you? You didn't exhibit any document that records this provisional undertaking that you described. That's correct, isn't it?
If it's not there, that's correct.
Okay. I mean, was there any record of Kuwait Flour or Kuwait Supply agreeing to pay AK Global directly?
There are bank SWIFT copies of AK Global receiving it, and I believe AK Global has a letter in the bundle confirming they got the money from Kuwait.
Okay, we've got the letter from AK Global. I'm not sure we've seen any SWIFT payments, but again, we can come back to it. We'll look at the documents that have been provided to us in the bundle. Okay, can we go to bundle D3? Tab 130, and it should be behind a tab A, so 130A. It's page 626.1. Okay, so I think this is the letter that you're referring to. It's a letter from AK Global to Amira dated 21 February 2018. And I just want to take you to the last sentence of this letter. What it says is, till the time we received outstanding payment from your side, payment for the current contractual shipments will be directly received in AK Global Business FZE account from Kuwait Flour Mills, and the monies received by us will be adjusted against the outstanding payments. Do you see that?
Yes, I do.
What this letter doesn't say is AK Global saying, thanks very much, we're going to keep all of the profit that we received on this transaction. It doesn't say that, does it?
It doesn't.
No, it says they're gonna make an adjustment to cover the outstanding payments.
Correct?
Correct. Okay. Okay. If we can stay in bundle D3, if we go to tab 139. So this is purchase agreement between Amira and AK Global dated 5 March 2018. And if you look over the page, it's for 8,200 metric tons. So as at 5 March 2018, AK Global is quite happy to enter into new contracts with Amira. Is that a fair assumption for us to make?
No, it's an execution document of the 30,000 ton contract.
So what, they were reluctant to enter into this agreement? You had to try to force them to enter into this agreement, or did they enter into this agreement freely?
I think I don't understand the question. I think I've been very clear. This is an execution document of the 30,000 ton contract.
Okay, so they were happy to continue with the arrangement that you'd agreed on under the 30,000 MT contract, correct?
With the addition of payments going directly from our customer to them.
Well, I'm not sure this contract actually says that, does it? No.
No, this contract doesn't say that, because again it's an execution document and we have directed our customer to pay them directly. And and the supplier confirmed that.
Okay, but AK Global had not received the payment of 4.134 million from the bank by this date, because the bank paid it on 20th of May 2018. So before they receive payment, they're entering into a new contract with Amira. That's correct.
It's not a new contract. I repeat myself. It is an execution contract of the 30,000 ton.
Okay, but again, this contract doesn't refer to any link between this contract and the 30,000 metric ton contract, does it?
This is an execution document of the 30,000 ton contract.
Okay. Well, okay. Let's have a look at the shipment period. Okay, turn over the page 643. Shipment period up to May 2018. Do you see that?
Yes.
You see that? Yep. And if we remember, the 30,000 metric ton contract dated 9th of January 2018 was for shipment up to March 2018, wasn't it?
Correct.
So this is covering a period that's not covered by the 30,000 metric ton contract, isn't it?
Well, in usual course of business, delays happen, and as a result, shipment times are extended as a result of that. Similarly, if you don't see IDBI and our history with them, this is a physical business. Goods are bought, sold, and shipped.
So you're saying what's written in the contract for shipment period doesn't really reflect the reality of the performance. Is that what you're saying?
What I'm saying is, it is extended mutually on execution.
But you're entering into a new contract here.
As just said,
Which
it
picks
is not
up-
a new contract. It's an execution document of the 30,000 ton contract. So this very clearly displays that by mutual agreement, this part of the execution of the 30,000 ton is up till May.
Okay, let's move on to the next point. Let's look over on page 644. Let's have a look at the price.
I also
The price
look at
is-
the price here is 1289. So, like I said, it is a part of the execution. Sorry, what was the next one?
Yeah, no, we're on to price. So price is 1289, which is
Correct.
I think you were ahead of me on this one. The price is very, very close to the price that's in the 30,000 metric ton contract, isn't it? So this is 1289. The 30,000 metric ton price is 128750. Very close, isn't it?
Excellent, yes. So if you do the mathematics, you look at the balance volume, it will come to around 1154. So had the 30,000 ton allowed in its full execution without disruption, that would have culminated in that money going to Wessing.
Well, is it right that Amira did not send this contract, 5th of March 2018 contract, to any bank in connection with arranging a facility or extending a facility or arranging finance? Is that correct?
I don't recall that right now.
You don't remember? Okay.
Can we take a break? I just need to use the gents, please. If the Honourable would allow.
Yes, certainly. Go ahead, Mr. Janata.
Thank you, Honour.
How are you going, Mr. Francis? How much longer do you expect?
That's a good question, Your Honour. I think maybe another half hour.
Right. And how long do you think you might be with the next witness?
Mr. Gandhi, Mr. Kuzikanani is going to be cross-examining Mr. Gandhi.
Same question.
About 1 hour, Your Honour. 1 hour.
The examination of Mr. Janata?
Not much. 15 minutes. 10 minutes.
Okay, well, if we sit on a bit this afternoon to try and finish off both these witnesses, we should be pretty right. Is that okay for all of you?
Yes, Your Honour.
Right.
Awesome.
Certainly fine for me, Your Honour. I am conscious that the transcripts, the transcribers have been at it for a little while now, and it has been a bit of a difficult task in some respects looking at the transcripts.
At least my apologies, I should have been thinking of your interests.
I just wonder whether a break now for their purposes might be a
Yes.
good idea, even if that leaves us sitting a little later.
Well, I think we should do that, but I would like to try and sit on to finish off the two plaintiffs' witnesses today.
Yeah.
Why don't we take a 10-minute break ourselves here? Would someone please, when Mr. Janata returns, inform him that that's what we're doing, and we'll resume, and he can have a little relax also. So we'll resume in 10 minutes, but the plan is to keep going.
All right.
Francis, should we just check that Mr. Janata has his access? Please continue. Thank you, Mr. Janata. We'll continue now.
Mr. Schneider, do you have A3 copies of a few pages of the S&P matrix to hand? I'm looking particularly at it says page 44 and 45.
Yes.
Yeah. So on page 44, we can use the SR on the far left side down to row 160. Okay, if we just go across to the column of date of balance payment received, it's blank, and the one preceding it is 14th of February 2018. Do you see that?
Yes.
So correct me if I'm wrong, but we understand that if it's blank, that is to indicate that Amira did not receive payment for that shipment from Kuwait supplier Kuwait Flour. Is that correct? If you look, it covers the next 17 down, so over the page.
Correct.
Okay, so it corresponds to 17 payments, no entry for date of balance payment received. And then we've got, I think it's, how many? 1, 2, 3, 4, 5. We've got 5 further shipments. So number 177 to 181. And let me just make sure I've got this right. The 177 to 181, these are 5 shipments that were received from AK Global. If we look at the other pages that you've got, so just a continuation of the table, 52, So page 52, and if we go down to row 177, we see there's a column, supplier's name. So for 177 to 181, we've got AK Global. Yes?
Yes.
Okay, so going back to our page 45, we go along from 177 and we see there's a date of balance payment received there of 5th of June. Do you see that? 2018. So page 45, row 177. And it's just below all of those 17 blank ones. You've got date of balance payment received, 5th of June 2018. Do you see that?
I do, yeah.
Yeah. And if we go across further, you've got a BL date, which I think is bill of lading date. And for 177, it's 21 May 2018. Do you see that?
Right.
Right. Okay. And then we go down that 1, 2, 3, 4, 5. So row 181, we've got a bill of lading 13 June 2018. Yeah? You see that?
Correct. Yeah.
So we've got 5 shipments around that date from AK Global where Amira has received payment as normal. Is that right?
I think I will have to ask to corroborate. One is blank. And it, as per the documents, it looks right.
Okay, that looks right. Okay, look, let's just check with Mr. Fritchie's table because he's taken the numbers from the S&P matrix and he's compiled them in a way that's probably a bit easier for us to see. So if I can take you to bundle C, tab 3C, just so we're clear on this point. And let's go to page 152.
Bundle C. Which tab, please?
Tab 3C.
Page.
It's tab 3C and page 152. It's very small, so I apologise, it might be difficult to read. But what I want to draw your attention to are the same row numbers, 177 to 181.
It's too small to read.
I'm sorry. Okay, take it from me, and Mr. Marchie-Smith will correct me if I'm wrong, but if we go across and we look at Mr. Peters' head of claim, where applicable, that column, we go down, 177 to row 181, these are described as unaffected shipments. So these are shipments that are not included in Amira's claim for lost profit. And you see the supplier is given as AK Global here as well. So my point is it right for us to understand from the S&P matrix that it was business as normal, resumed for these 5 transactions with AK Global?
Probably yes, because 30,000 is the total contract, and we have the execution documents of that.
So probably yes. Okay, let's go to bundle D4. And let's go to tab 182, please.
Say that again.
Sorry, D4, then tab 182.
Yes.
Okay, so this is the AK Global letter to Amira dated 28 June 2018. And it states at the top that they've just received the 4.134 million. So this is the payment made by IDBI. And it refers to a number of visits from Amira. below the table, as per your visit in our office, 2nd April, 1st May, 21 May, 3 May, 28 June. Now, are you aware of any record of what was discussed during those meetings?
No, I don't recall it right now. I think these visits were done by my colleague, and from what, just summarizing what I recall is, trying to get them to work with us and assure them that IDBI is paid, should be business as usual. It's general business discussion. I don't recall anything more than that.
Okay, but just focusing on what's said in this letter, it doesn't provide or doesn't explain any reason for AK Global's decision to no longer do business with Amira, does it? In this letter, they don't say we're not going to do business with you because of.
I think the letter is self-explanatory on its contents.
Yes, it is. And also, what's self-explanatory about this letter is it doesn't explain what AK Global intends to do with any profit that it's holding that should be payable to Amira, does it?
I can't speculate what it does. I think the letter is what it is.
Well, it's not stated in the letter, is it? That's self-explanatory from the letter, isn't it?
That's your assumption.
Okay. And then they say that they've decided not to do any more business with you or cancel all pending contracts. You did not write back, or Amira did not write back in response to this letter and say, you've got no right to terminate these contracts. We're going to take you to court, we're going to take you to arbitration, we're going to claim all of our loss and damage as a result of you terminating these contracts without any right. There's no letter that you wrote, or Amira wrote to AK Global, saying anything like that, is there?
As a matter of fact, post the IDBI default, I don't think we had a contention to do this. They cooperated with us, made the balance shipment whatever they could, and we even paid them directly from our customer. We actually expected them to continue business. So it wasn't something we expected them to do, but at the end of the day, this is what happened.
Okay. Well, let's just provide a bit further context. So you've signed this 30,000 metric ton contract with them, and you'd agreed to pay AK Global. Amira had agreed to pay AK Global $1,287.50 for that 30,000 metric tons. So that's a total purchase price, a total payment to AK Global of $38,625,000 US. That's correct, isn't it?
If your maths is correct.
Yeah, and it's Amira that has the direct contracts, the relationship with Kuwait Supply, Kuwait Flour, not AK Global. That's correct, isn't it?
Until we asked Kuwait to pay AK Global directly.
That's not quite my question. You're not aware that AK Global was entering into its own contracts with Kuwait Flour or Kuwait Supply?
I am not aware of anything like that.
No. And AK Global isn't the only rice supplier in this part of the world, is it?
I think in my correction of my statement, I have stated that there are other suppliers which we had to go to, and I think we paid a higher price. So I take you back to my statement where 4,000 tons is by TIA and 9,600 is by Impulse SR Agro.
My question is simpler. Let me rephrase. Sorry, please go ahead.
No, go ahead.
Okay. What AK Global is supplying, rice, that's a commodity, isn't it?
It's a specialty staple, not a commodity. Commodity normally gets traded down in exchange. Specialty staples are done in a physical form like basmati rice.
Okay. But it's a commodity, you'd agree with me?
No, I do not.
Okay, rice is not a commodity. Okay, that's your evidence. Okay, what
I have said
what I'm
that in my
struggling
public
with
statements as well, because there is scientific evidence to prove that basmati rice is a specialty staple.
Okay, well, let me move on. What I'm struggling with here is, what sense does it make for AK Global to walk away from one of its customers that is entering into these sorts of contracts with it, agreeing to pay $38,625,000 US to it over the course of 30,000 metric tons? Doesn't make any sense for them to walk away, does it?
I can't speculate on what they are thinking.
Okay, you're right, let's not speculate. Okay, if we can turn to your third witness statement.
Can you tell me the time?
Okay, this is bundle B, tab 7. And if we can go to page 59. So what I'm looking at here is your very helpful diagram here. So these circles here, and just going through each of these circles, I couldn't see any mention. So this is the normal business cycle between Amira and AK Global and banks. Okay, so we've got A, B, C, D onwards to F. This is the usual business cycle, yes?
Yes.
Now, there's no part of this business cycle that you've described in your witness statement that would involve AK Global making a payment to Amira.
No, not yet.
No. So then, AK Global was making payments to Amira directly, wasn't it?
Can you remind me where?
Well, do you recall AK Global making any payments direct to Amira
I
in
don't.
2018? You don't remember any. Okay?
Not right now.
Okay, fine, not right now. Let's see if we can refresh your memory. You can go to bundle D4.
Yeah. Yes, please.
And let's go to tab 177A. Okay. So these are Amira's Mashreq bank account. So this is, let's just remind ourselves, this is the bank account where Amira prefers to hold its profits.
Correct.
And, yes. And let's go to page 721.3. We see here, if you look at the date, the top payment, so the date 1st of May 2018, inward remittance, let's look at the transaction remarks. AK Global Business, FZE, claim settlement, $197,000, 445. Do you see that?
Yes, I do.
Yep, you don't remember receiving that payment, or Amira receiving that payment?
We have payments going in and out. I don't remember it receiving this payment, no.
Okay, let's go through a few others of these. Let's go to 721.11. Have that? You have that? Look at 30 May 2018. Inward remittance, again, transaction remarks. AK Global Business, FZE, invoice against claims debit note. The amount, $244,000 US dollars, 995. Do you see that?
Yes.
And no recollection of Amira receiving that payment either.
No.
Okay. Let's go to tab 185A. And let's go to page 734.4. again, these are other Mashreq bank statements for the same US dollar account. Let's look at 9th June 2018.
So
See that?
75. What's the page number, please?
Sorry, 735.4.
Yeah.
See that?
Yes.
Yeah. So 9 June 2018, again, inward remittance, AK Global Business FZE, payment against claims debit notes, 199,000 US dollars, 950. Do you see that?
I do.
Yeah. And I'm guessing you don't remember anything about receiving that payment either. Is that
I
right?
don't follow payments like correct.
Okay, let's speed through some of the rest. So, page 735.5, 9th of June 2018, another one, inward remittance, AK Global Business FZE, payment against claims debit note, this one for 149,000 US dollars, 970. Let's go to the last one in US dollars, 735 page 8, 14 June 2018, inward remittance, AK Global Business, against rice supply claims, 305,000 US dollars, 395. Okay, so adding all of these sums up in the dollar account for this period, so from 1st of May to 14th of June, total dollar amount received from AK Global to Amira's Mashreq bank account is 1,097,755 US dollars. Now, I know if I'd seen that amount being paid into my bank account, I'd remember it.
Well, I'm sure you would be, but this is a business and it receives and makes payments every day. I don't remember payments.
It's a
Neither do I
substantial
look at bank
payment
statements.
over the period. It's a substantial payment. Sorry, please go ahead, Mr. Chinana.
All I'm saying is day-to-day ins and outs are not something I look at. And it's a business. It's not a personal account that you remember what you're sending out or bringing in.
Okay. Right. Okay. Well, those are all the documents I want to take you to. But I wonder if I could just go through some figures with you in respect of the profit that Amira was expecting to receive under the 30,000 MT contract. So you were selling to Kuwait Flour for 1,398 per metric ton. So if we take away the price that you're paying under the 30,000 metric ton contract to AK Global, so 1,398 minus 1,287.50, you've got a profit that's payable to Amira of $110.50 per metric ton. So
Correct.
the total profit, okay, correct. So the total profit payable to Amira under the 30,000 MT contract is 3,315,000 US dollars, correct?
Right.
So that's for the whole 30,000. If we divide that by 3 to work out what profit is payable for 10,000 metric tons, we get $1.1 million and $5,000, don't we?
I guess if the maths is right, correct.
Yeah, which is very close to the total sum that we just went through and totted up as being received as direct payments from AK Global into the Mashreq account of $1,097,755.
So,
Yeah. So the payments received by Amira from AK Global into the Mashreq bank account is enough to cover the profit that would have been payable to Amira for the delivery of 10,000 metric tons under the 30,000 metric ton contract. That's correct, isn't it?
that's your reduction, but look at the 30,000 contract in its full.
Okay. Well, it's a matter of maths. We can come on to it between the lawyers, I think. Let's go to one other document. Actually, let's go to tab D4, tab 188.
Yes, please.
Okay, this is a letter from Bank of Baroda to Amira, dated 9th of August 2018, titled Review of Your Credit Facilities. Okay, if we can just turn over the page and go to page 748, I just want to focus for a bit on the additional terms and conditions that Bank of Baroda wish to apply on any new facility with Amira. So, just starting with number 2, company to submit the reason for low turnover with our bank. So, my question to you is it right that Bank of Baroda, so a bank where you've got credit facilities, was also used for low profit transactions in the same way as IDBI's bank account?
I don't recall exactly the transactions of Bank of Baroda in isolation.
Okay. Well, item number 3. Bank of Baroda says, additional term and condition, credit facilities will be allowed only for genuine trade transactions. So, is it right for us to assume that Bank of Baroda was concerned that Amira had been using its account for trade transactions that were not genuine?
That's an incorrect assumption.
Okay, it's an incorrect assumption. Okay. And then number 4, facilities cannot be utilised for transactions with associate or sister concerns. So, is that a wrong assumption or a wrong inference to draw from the Bank of Baroda term and condition there? Were they concerned that Amira was using the bank account for transactions with related parties?
I believe that assumption is incorrect, and I also think that all this came about post. I believe there was some noise in the banking in India about transactions being done by different individuals. This is not regarding Amira. So I think general conditions have been added. That's my assumption.
Yes, that brings us back full circle. This is the fraud. This is you're referring to the fraud on Punjab National Bank, if I'm correct, which was to do with letters of credit. Okay.
I don't remember which bank or what exactly, but like I said, I can only assume from this because none of this relates to us.
Yes.
What you asked at the moment.
Thank you. Okay. Thank you, Mr. Chanana. There's no further questions from me. Mr. Montague-Smith may have some questions. Thank you.
Yes, Mr. Montague-Smith will ask you a few more questions and then you'll be glad to get away, I think.
I won't be long.
Mr. Montague-Smith.
I won't be long. Thank you very much. All right. I'm just going to take the issues that I want to deal with you, Mr. Chanana, in the order that they were asked of you, because I'm afraid that's the order my notes are in. And I've just got a very few sweeping up questions for you. Firstly, you were asked about the contract with AK Global, the supply contract for 30,000 tonnes. And it was put to you that there was no explanation of how that 30,000 tonne contract interacted with the 10,000 tonne contract in your second witness statement. And when you were asked that, you said that you thought that it was dealt with by the experts. Can I ask you please to pick up bundle C, tab 1, page 13.
Yes, please.
If you look there at paragraph 4.10, is that the explanation you were talking about when you gave your evidence earlier?
Correct.
I'm going to skip over a couple of these. You gave an answer in your evidence when asked. You said that the rice that was being supplied under these contracts was not a commodity, and the question was repeated afterwards, suggesting that that was an odd conclusion. What kind of rice were you supplying?
We were supplying basmati rice. Now, basmati rice is best described like champagne and wine. It's not a commodity. It comes from a very defined region, has the same geographical, legal protection like champagne does for its region. And similar to wine, it needs to be aged for although a very short time. As a result, and these are just some of the factors which differentiate it. Basmati rice is not a commodity, it's a specialty staple.
Speciality staple, thank you. And in the last set of questions, or towards the end of the questioning, you were shown some copies of bank account statements from Mashreq Bank, and you were asked about some payments, which it was said, and I haven't done the maths, but it was said added up to a total of just short of $1.1 million. Do you know what those payments related to?
Not at the top of my head right now. They could be relating to shipment claims or shortfalls in supply because the customer would then either claim or pay less over the total contract. So I will have to see. I don't recall on top of my head what those payments are.
And who might have that information? Who might know what those are about? What those payments are about?
I think the office would have it. We can dig out what they are.
And Mr. Gandhi is about to give evidence. Will he know the answers to those questions? Would he be in a position to understand what those statements are about? Those payments
I think
are about?
given the time, he can definitely. I think if he has the paperwork on him, he should be able to. Otherwise, he'll have to get it and explain it.
Understand. Thank you. There is one further observation, which, with regret, I'm going to have to raise about the cross-examination, but I don't think that it will affect this witness's evidence. I have a point to raise about the way in which some of the questions were put, or one of the questions in particular was put by my learned friend, but subject to any further documents actually being introduced at this stage in light of the questioning, I don't think it will affect the evidence that Mr. Chanana is going to give. Now, it may be once I've raised this issue with you that there are a number of different ways that you could resolve that. You might say, we'll pick it up in closings and you can make your submissions on it. I'm happy to do that now while Mr. Chanana is still under oath and still sitting there. I can explain my position in relation to that, or we can end this evidence now. I don't think it's necessarily likely that he will need to be recalled, but it is an unusual situation and there are a range of possible outcomes.
Do you see the possibility that in the light of what you're going to say to me, some more questions might be asked of Mr. Chanana?
It's not impossible.
Okay,
I think it's unlikely, but it's not impossible. I don't propose
it would be foolish to do away with Mr. Chanana's presence.
Yes, all right. Perhaps if he's happy just to wait there now, I can make the point that I was going to make to you.
Will it matter if he hears what you say?
No, I don't think it will. I don't think that matters.
Right. Well, in that case, the best course, I think, would be for me to hear what you want to say, Mr. Chanana. If you would just relax for a moment. With any luck, we don't need back to you.
Thank you.
Now,
yes.
The difficulty is unusual because we are in a situation where the lawyers in the court have seen certain documentation, but that documentation has not been admitted into evidence. Now, there are a number of ways in which the court can deal with that, and the advocates and lawyers can deal with that. They can say, in submissions, for for example, the evidence on the face of the record in front of the court doesn't support factual assertions that are being made. What they cannot do in my submission is put to witnesses factual assertions which they know not to be true, or which those amongst the legal team know not to be true. I tried to raise this with my learned friend, first during the break and then shortly just before we started again. He didn't feel he had the time to hear what I had to say about this. But it is an important and serious point. The questioning that he undertook was on the basis, he took Mr. Chanana to certain invoices, and he said, isn't it right that there are no other invoices of that nature? No other, and this was about the invoices and whether those, and the payment obligations that were recorded in those invoices. And the point that was being made was that there were 3 in the bundles which required payment direct to AK Global. And the question that was put was, there are no other documents like that? And he said, we have not seen any in their invoices. Now the difficulty arises because there are other documents. His team have seen those documents. And so the problem arises in the way in which that question was put. I can see that submissions can be made at the end, on the face of the evidence that Your Honour has. What you cannot do, it seems to me, is make a suggestion to the court or to the witnesses that documents don't exist when you know that they do. It's a difficult position, but that is what has happened. Now there are 2 solutions to this. One is we just move on and we make our submissions, and I make my submissions on the questioning, the line of questioning that was advanced. The other is that, in fairness to the witness, you allow him to look at the documents and introduce the documents in that way. I don't say I need those. I'm not trying to fill a gap in my case. I leave it in Your Honour's hands as to how to deal with that. As I say, I raise this with regret, try to deal with it in a different way, but it seems to me that the way the questions were put have crossed that line. I never had to be in a position to say that sort of thing before, so I say it with great hesitation, but with consideration.
From time to time, questions are asked, are there documents in the bundle?
Yes.
No problem with that. Sometimes that's straight into, are there documents, full stop?
Yes, no problem with that.
No problem with that. There was at least once a comment, I have not seen any, but that is a comment which I regard as quite irrelevant. It does not matter what counsel says. And that's how I propose to deal with it.
I understand. I think the question that was put also was, they don't exist. That's the difficult. I'm happy for.
An assertion from counsel is not evidence and is ignored.
Well, if it. Well, ignored, but ignored for what purposes? I take Your Honour's point. We can take it up going forward, but that's. I flag it now, and let's leave it there.
I must confess I cannot see a problem emerging from this. Undoubtedly you are right that propriety involves that counsel should not want something known to be incorrect. I'm not going to say anything about whether or not that has occurred. It's something that should not occur.
I'm grateful.
I don't think that at the moment I don't see that there's going to be a problem in submissions.
I understand.
And I make it plain that where counsel, by way of a comment, makes a statement of that kind, that is not evidence and amounts to nothing.
I understand. Right, I'll leave it there. There it is. I'm grateful. I don't have any further questions for Mr. Chanana.
Well, is there any reason why Mr. Chanana should not be excused as a witness?
Not from our side, Your Honour. I would like to just put on the record a response to Mr. Montague-Smith's point. I mean, if there's any suggestion that I have made a statement that there is not a document in existence which I know not to be true, that's rejected, that's false. Whether a member of my team or we've been provided with some document which is not in the record, that's another question. I'm happy to deal with a specific example in closings or outside, but I just want to reassure the court to make it clear on the record I'm not making statements which I know to be untrue.
Well, as I said, I'm not going to comment department, and I think we all know the way things should be conducted. And it's not at all an unusual course that counsel know of materials which are not in evidence and may affect things, and you have to tread carefully around it. That's the situation we're in. Mr. Chalana, thank you very much for your assistance. You're excused as a witness. Thank you indeed.
Thank you. Thank you.
All right, does that take us to Mr. Gandhi?
Thank you. Happy Mr. Gandhi's in court, so if we take a moment, we can probably terminate the Olympics to interrupt. But in the meantime, if Mr. Gandhi...
Well, let's get Mr. Gandhi moving, and I don't know whether we need the ET people to do the termination or not. I don't see why we shouldn't get Mr. Gandhi moving.
Yeah, he's on his way.
Could you please state your name and then read the oath? I swear by what I believe to tell the truth and nothing but the truth.
I, Vish Gandhi, swear by what I believe to tell the truth and nothing but the truth.
Thank you, Mr. Gandhi. Has someone told ET that we could please stop? Yeah, thank you.
Someone else, yeah.
Yes, please, Mr. Montague-Smith.
Thank you. And there it goes. Excellent. Thank you. Mr. Gandhi, you should have set of bundles, I think they're to your right. If you could look in those and find bundle B for me, please.
Yes.
Yes, you took it out and open it up at tab 5, please. Can you state your full name and address for the court, please?
Full name Divyesh Gandhi, address 405 Al Noor Building, Dubai, United Arab Emirates.
Thank you. And when you give your answer, there's going to be a series of questions coming to you. When you give your answers, can you try and speak loudly? There's not an awful lot of amplification, but also slowly, particularly for the benefit of the transcript.
Okay.
Thank you. You should see there in front of you, tab 5, a copy of your witness statement. Can you confirm that that's your statement?
Yes.
I believe there is one minor correction that you wish to make.
Yes.
Can you tell me what it is, please?
That's my name. It's the spelling is wrong. It's
So-
D-I.
So just below item A, introduction, they've,
Yeah.
they've misspelled your name. Thank you. Are there any other corrections that you need to make?
No.
I see. Thank you. All right. And if you turn forward, please, to page 47. Do you see your signature there?
Yes.
And can you confirm that you believe that the facts set out in this witness statement are true?
Yeah, I believe.
Thank you very much. Your Honour, again, I have some relatively short questions in chief, if I may. Firstly, just really to orient that document that we've been looking at, the S&P matrix. And then there's been some suggestion in relation to the management time claim that the quantum of the salary and bonus is recorded by the experts. But I just want to get on record whether or not that is accurate. I don't think I want to ask him about anything else.
Is there any objection to that amplification?
No, Your Honour.
Yes, go ahead.
Thank you very much. So, if you can put away bundle B, please, and pick up bundle C. And if you could open up tab 1A, please. Do you see there a document behind tab 1A? On page 32, it's described as the sales and purchase matrix, and then it runs from page 33 onwards.
Yes.
Page 60.
Yes.
Can you tell me what that document is?
This is sale and purchase matrix. Sales and purchase matrix.
Yes.
We have sales and purchase recorded in it. Purchases, first we record purchases based on the shipping documents what we receive from suppliers, like invoice copies, bill of lading, and then we forward the documents to buyer and we record the sales on that basis. So this is record of sales and purchase.
And who created this document?
This is created by me.
By you.
Yeah.
And when would you have created it?
Once we receive documents from supplier, the invoice and bill of lading.
So is this a document that was created for these proceedings, or a document that has existed at least in some form prior to these proceedings? Or when was it?
This we are doing on regular basis.
On a regular basis. And what was the source of the information that you used to compile the entries in this document?
The source of information is starts with the supplier invoice and bill of lading.
And very briefly on the management time issue, can you tell me please what is and was your salary, including your bonus?
My salary is per month 22,000 grams and bonus is yearly 40,000.
22,000 dirhams per month, was that?
Yes, sir.
And 40,000 dirhams bonus per year?
Yes.
And how many hours would you normally work? Were you contractually obliged to work?
6 days, 8 hours per day.
6 days?
Weekly 6 days.
Thank you. Your Honour, I've got no further questions on that. So if you'd like to wait there, there'll be some further questions.
Yes, thank you.
Good afternoon, Mr. Gandhi.
Yeah, good afternoon.
I'd like to start by taking you to bundle D3 and the tab 134.
I wonder, would it be possible, would it be easier for Mr. Gandhi if you were over here so that he didn't have to turn left all the time?
That's fine, Your Honour. I just need to move some files over.
Let's do that.
Okay, Mr. Gandhi, do you have bundle D3 with you?
Yes.
And tab 134?
Yes.
That should start on page 631. Is that right?
Correct.
Okay, so what we have here is an exchange of emails between you and IDBI personnel at the end of February 2018. Is that correct?
Yes.
And if you could turn over to page 633,
Yeah.
and at the bottom of that page, we have an email from you to IDBI dated 24th of February 2018, requesting that IDBI provide Amira with a quote for an extension of the buyer's credit falling due on 26th of February, and an update on the payment to AK Code. Do you see that?
Pardon?
So at the bottom of that page, we have an email from you to IDBI,
Yeah.
and in the first paragraph, you request a quote for extension of the buyer's credit falling due on the 26th of February 2018.
Yes.
See that? And then in the second paragraph, also update us on the payment to our supplier AK Global Business FZE against the funds received on 14th of February 2018.
Yes.
Yeah. And then just above that, in the middle of that page, we have Mr. Ravi Kamal's response to your email on the 24th of February, the same day. And he says, no extension of the BC is possible, kindly organise to make the payment on the due date. You
Yes.
see that? Then we have your response on the previous pages, 631 and 632.
And if you look at the bottom of page 631, you responded to Mr. Ravi Kumar's email on the 25th of February, so the next day. Yes, did you see that? And the substance of that response is on page 632.
Yeah.
So I just had a couple of questions about your response on page 632. So paragraph 3 of your email, you refer to the supplier purchase contract for 10,000 metric tons.
Yes.
And that's the 10,000 metric ton contract with AK Global, isn't it?
Yes.
And you're saying here at paragraph 3 of your email that AK Global has already made shipments of 3,000 metric tons. Is that
Yeah.
correct?
Yes.
And the 7,000 metric tons is at the port, at the loading stage.
Yeah.
So here you're telling the bank that the shipment and payment in respect of 7,000 metric tons of the 10,000 metric ton contract is at risk due to IDBI's non-payment. Is that correct?
Pardon?
So here in this paragraph, you're communicating to the bank that the balance of the 7,000 metric tons under that contract is at risk due to IDBI's non-payment or its delay in payment. Say here, supplier would hold all the shipments which has delayed inward remittances which are expected to receive in account on or before 26th of February 2018 to settle as credits to be due on the 26th of February 2018. You're communicating here that as a result of IDBI's actions, there's a potential risk of this 7,000 metric tons.
Yeah.
Thank you. And then if we could move on to paragraph 6 of your email, you then state, the current market price of the cargo is going up, and we're losing a lot due to non-payment to the supplier. They're demanding higher price. So when you refer to the supplier here, you're again referring to AK Global?
Yes.
And you're saying that AK Global is demanding a higher price for the rice shipment?
They might.
Sorry? Yes. Sorry? They might. Thank you. So the price that you'd agreed with AK Global under the 10,000 metric ton contract, AK Global wasn't treating that as binding?
Pardon?
They weren't treating the price that you'd agreed under the contract as binding?
Maybe they will. They will agree.
They will have, sorry?
They will bind the contract price.
So they would bind the contract price under the 10,000 metric ton
Yes.
contract. So your point about them demanding a higher price, that isn't accurate.
For the future shipments.
For the future shipments. So if I could ask you to turn over to tab 138, please. It's in the same bundle.
Yeah.
And at page 641.
Yes.
So in paragraph 4, this is a letter from you to IDBI, dated 28th of February 2018. That's correct?
Yes, correct.
And at paragraph 4, from the second sentence, you say, now the supplier is also backing out of the contract. We have to look for alternate supplier who are quoting higher prices and also advance payment, which we're not in a position to manage. That's correct.
Yes.
Okay. And if I could now ask you to turn over to the next tab, at tab 139, on page 642.
Yeah.
So this is a purchase contract for rice shipments dated 5th of March 2018, 7 days after your letter that we've just been to. Yep. And this is a contract for shipments that are subsequent to the shipments that would have been made under the 10,000 metric ton contract. So
Yeah.
next shipments. Yep. And it's between Amira and AK Global.
Yes.
If we turn to the last page of that tab, which is bundle page 647,
Yes.
it's been signed by you, Mr. Gandhi, is that correct?
Yes.
Okay. Now, if we could turn back to page 644, this contract,
Yes.
we can see there that the price is 1,289 per metric ton.
Yes.
Now, that's higher, sorry, that's less than the price under the 10,000 metric ton contract, isn't it?
Yes.
Okay. And that's $89 cheaper per metric ton than the 10,000 metric ton contract. Is that correct?
Yeah, it matches.
Yep. So you'd agree that it's $89 per metric ton cheaper than the 10,000 metric ton contract. Is that correct?
Yeah, if your maths is correct.
If my maths is correct. Okay. So we can actually go to that contract if you'd like to check. The 9th of January 2018 10,000 metric ton contract is at bundle D2 43, tab 43.
D2.
Do you have that? It should start on page 441.
Yes.
And if you turn over the page to 443,
Yeah.
top of the page there you have the price. Price is USD $1,378 per metric ton.
Yes.
So that's $89 more than in the contract we've just seen, which was the 5th of March. Okay. So it appears AK Global changed its mind and wasn't demanding a higher price for next shipments from those two contracts. Would you agree with that?
No, as it's under the umbrella contract, the prices are decided as per our requirement.
Yep. But in response to my question whether AK Global was demanding a higher price, you said for the next shipments. Now, you've also said that the 5th of March contract was for subsequent shipments to the 10,000 metric ton contract. That's right?
No, it's under the same umbrella contract of 30,000.
It's under the same contract as the 10,000.
30,000 umbrella contract.
So it's under the 30,000 metric ton contract.
Yeah.
But it's for later shipments than the shipments that would have been provided under the 10,000 metric ton contract.
Pardon?
The shipments that would have been made under the 5th of March 8,200 metric ton contract.
Yeah.
Those were shipments that would have been actioned after the shipments under the 10,000 metric ton contract.
Yes.
Yes. And in your letter to IDBI that we'd already been through, you said that AK Global was demanding a higher price for rice for the next shipments.
For next shipments, not under this contract of 30,000 metric ton.
So a different contract to the
Yeah,
30,000
it will be different contracts which will
metric ton. Okay. And just so that I'm clear, the 5th of March contract, that's not something that you provided to IDBI on the 5th of March 2018.
No.
And is it something that you provided to IDBI yourself since? No. Is that a no?
No.
No. Okay, thank you. So if I could get you to turn to your witness statement now. It's in bundle B, tab 5. You can put those two bundles away. Okay, and tab 5, do you have that?
Yes.
Starts on page 40. You could turn over to page 42, please.
Yes.
And at the top there, you say that you're a trained accountant.
Yeah.
And on the previous page, page 41, below paragraph 8, provide a table of Amira's annual revenue in 80 million. That's right, isn't it?
Yes.
Yeah. And you project a fall in revenue and gross profit for the year end 2019 as against year end 2018. That's right, isn't it?
Pardon?
You project a fall in the year end 2019 versus year end 2018.
Yes.
But you haven't referred to or exhibited any documents in your witness statement to support that projection, have you? For the transcript, please, Mr. Gandhi, was that yes or no?
Pardon?
If you could say yes or no to the question.
Pardon the question?
So the question is, are there any documents referred to in your witness statement to support the projection for the year end 2019?
No.
Thank you. So turning over the pages in your witness statement to paragraph 23, which is on bundle page 44. Do you have that?
Yes.
So paragraph 23, you say that after AK Global refused to conduct further business with Amira, Amira entered into a new contract with TIA Agro. Is that correct?
Yeah.
And then at paragraph 24, you say that after the TIA Agro contract concluded, Amira entered into a contract first with Impulse and then with SR Agro. Is that correct?
Yes.
And you say that the margins for those contracts are reduced as against the AK Global contract.
Yes.
Is that correct? Yeah. Okay. If I could ask you to turn to volume D4, please. Bundle D4. And tab 175, please. Should start on page 714.
Yes.
That's the TIA Agro contract, isn't it?
Yeah.
Dated 26th of May 2018.
Yes.
Okay, so I'd like to take you through a few differences between the TIA contract and the AK Global contract. First of which is on page 714. So you see there on the line commodity, see that?
Yeah.
That this contract is for new crop 2017. You see that?
Yes.
And the AK Global contract was for the previous year's 2016 crop, wasn't it? If you'd
Yes.
like me to show you the contract, I can do.
No, it's
It's
2016.
for the 2016. Thank you. And then on page 715 of the TIA Agro contract, so just turning over the page,
Yeah.
we've got shipment and shipment period at the bottom of that page. Do you see that?
Yes.
And there it says up to September 2018.
Yeah.
And that's obviously different to the one under the AK contract, which was up to March 2018, wasn't it?
Yes.
Thank you. If you turn to page 716, so it's just over one page.
Yes.
There at the top you have the price,
Yeah.
and it's 1,318 per metric ton.
Yes.
Yeah, okay, thank you. So the same bundle, if we could turn to tab 189, please. You have that?
Yes.
And it starts on page 750. So that's the SR Agro contract.
Yes.
And this is also for the 2017 crop, isn't it?
Yes.
If we turn over the page, 751, you can
Yes.
see that the shipment period there at the bottom is up to December 2018.
Yes.
So that's also different to the AK Global contract, isn't it?
Yes.
And there, if you just look on the next page, page 752, you can see that the price per metric ton is $1,389.
Yes.
You can put those bundles away, Mr. Gandhi. If I could ask you to pull up bundle C.
Mr. Kurzkanani, we seem to have an awful lot of going to documents, saying what they say, he agrees with what they say, and then we move on.
Okay,
We can all read documents.
I appreciate that honour.
Just a hint for the future, perhaps.
Thank you. That's very kind of you. We'll be going to one document now for the rest of this line of questioning. Hopefully there won't be so much back and forth.
Well, I hope it goes beyond just getting agreement as to what it says.
Okay. Thank you, Your Honour. So, do you have bundle C in front of you, Mr. Gandhi?
Yes.
Could you turn to tab A1A, sorry. Which starts on page 32.
Yes.
And this is the sales and purchase matrix that you were talking about just before I started to ask you some questions. If you could turn to page 52 of that sales and purchase matrix, please. Is the blow up including page 52?
Yeah.
I'll be turning to one page which I think isn't on the blow up, so feel free to refer to the blow up for page 52, but we will be also coming on to page 52.
It's not. We've got some copies of
That'll be fine, or at least for the witness.
it. If it's helpful to you, to your question, I'm afraid they're loose, but.
I don't need one, if we were, that's fine. I'll grab that.
Does you want
If
to
that's
help?
an
If you want
issue
to
with age, can I have one too?
Yes, sorry. I'll give you most of the room. So apologies.
No, I've got the lot, haven't I?
That's the whole thing.
Oh dear. Shouldn't have asked.
It's the danger. Sorry, I feel like I've made more confusion than this did. I do apologise.
Well, at the end of this, I'll extract whatever was the subject questioning to Mr. Gandy. It would be the best way.
Okay, Mr. Gandhi, on page 52, let's see if we can shortcut some of this, and if not, we can go to the various cells. So, from line 182 onwards, we have the TIA contract, Impulse contract, and SR Agro contract, sales information. Sorry, purchase info.
Okay.
Is that correct?
It's TIA and Impulse here in 52.
Yes, so you have the TIA contract from 182 to 189, then the Impulse contract from 190 to 201, and then turning over the page 202 to 214 is the SR Agro contract
Yeah, yes.
information. And in the sixth column from the right, you have the rate per unit USD. You can see the description of that column in the top if you need to find it, but it's 6 cells from the right. And that's the purchase price.
Yes.
So that's the price at which Amira bought the rice from those new suppliers.
Yeah, correct.
And in each case, under all those 3 contracts, the price was USD 1389 per metric ton.
Yes.
Thank you. Now, if we turn back to page 38 of the same document, I'm not sure there's a blow up of this or anything else provided with one.
Yes.
Again, hopefully we can shortcut this, but this is the corresponding section of the sales and purchase matrix which deals with sales information for those same contracts.
Yeah.
And in the 4th column from the right, you have the rate per unit, USD,
Yes.
and that's the sales price.
Yes.
So that's the price that Amira achieved on the shipments that it received from TIA, Impulse, and SR Agro in rows 182 to 214.
Yeah.
And in each case, the sales price was USD 1,549 per metric ton.
Yes.
So deducting the purchase price of USD 1389 per metric ton from the sales price, in this case to Q8 flour, of USD 1,549 per metric ton, gives Amira a profit margin of 160 per metric ton. Is that correct?
Yeah, it matches correct.
And that's better than the profit margin of USD 110.50 cents that Amira achieved under the contract with AK Global, isn't it?
Yes.
Yes, okay. So on your own sales and purchase data, you can see that the transactions under the contracts with TIA, Impulse and SRR Agro provided Amira with an increase in the profit compared with its transactions under the AK Global contract. That's correct, isn't it?
Yes.
Thank you. If I could ask you to turn to paragraph 28 of your witness statement, which is in bundle B, tab 5. And it's on page 45 of that bundle. Do you have that, Mr. Gandhi?
Yes.
So in that paragraph, you refer to the lost opportunities which you say have resulted from IDBI's failure to make payment to AK Global under the irrevocable letter.
Yes.
And you refer, underneath the table, there's 2 paragraphs, and it's the second paragraph that I'd like you to look at. You say that Amira has lost an estimated profit of USD $4,000 as a result of not being able to establish a letter of credit for a shipment to a Bangladesh buyer. Is that correct?
Yes.
40,000.
40,000.
Yeah. And the only document you refer to here is an email dated 6th of June 2018, and we can turn to that now. It's at bundle D4, tab 138. page 722.
Yes.
You have that, Mr. Gandhi. So this is an internal email, isn't it? As between Amira employees.
Yes.
Mr. Majumdar is an Amira employee.
Yes.
Thank you. And now if I could ask you to turn back to your witness statement, paragraph 34, which is on bundle B, page 46.
Yes.
So at paragraph 34, you say that you spent considerable time dealing with documents for KFM, seeking alternative sources of funds and effecting various documents with new suppliers, and other issues surrounding the dispute with the defendant that could have been devoted to the first claimant's business. That's correct.
Yes.
And you recorded that time in a table which you exhibited to your witness statement.
Yes.
You can turn to that now. It's at D4, tab 193. Page 769.
Yes.
You have that?
Yes.
You prepared this document after the 28th of November 2018, is that correct?
Yes.
Okay. And you didn't provide any documents to support the time recorded in this table, did you?
No.
And these are estimates of the time spent.
Almost near to actual.
Near to actual.
Yeah.
But if we look at page 769, in the top right-hand corner, it says estimated time spent in minutes. So it's described as an estimate, isn't it? Thank you. And the time includes the time you've spent actually preparing this table. Is that right?
Pardon?
Does the time that you've included in this table include the time preparing this table?
Yes.
And that's, for the record, it's page 777 at the bottom.
Yes.
That's your time spent preparing this table. And it's 600 minutes, so 10 hours of time.
Yeah, almost.
I just have one more question. Obviously, there were some questions about your salary and your bonus. Amira hasn't disclosed your contract of employment in this proceedings, has it?
No idea. I'm not aware about it.
Okay, you can take it from me that it hasn't, and if counsel to the other side disagrees, I'm sure they can address that in evidence. Redirect. Okay, thank you very much, Mr. Gandhi. That's all from me.
Thank you.
Anything?
Just something very short. I don't know whether it's relevant, but I'll just picking up on a question that was asked of you. If you pick up your witness statement, please turn to page. It's bundle B, tab 5, page 41. This may go nowhere, but paragraph 8, you were asked to look at a table, and the table, the final column, has some projections in it.
Yes.
And it was said you haven't attached any documents to the back of this. What were those projections based on?
Yes.
What were they based on? How did you arrive at those projections?
No, it was based on our sales team's target.
I see.
They will give us the information that they are planning this much orders. So based on that, we prepare this sales data projections.
I understand. Thank you. I don't have any further questions. Does Your Honour have any further questions?
No. Any reason why Mr. Gandhi should not be excused as a witness?
Not from me, Your Honour.
You are, of course, free to remain and observe, but as a witness, you're free to leave.
Okay. Thank you, sir. Thank you very much.
Taking stock, how's the time going?
Well, we are remarkably on track according to the trial timetable that was agreed. It's my turn primarily tomorrow morning. I'm hoping to get through both witnesses in the morning. That's my aim. As ever, it's hard to know whether that will happen. And then the experts in the afternoon. Now, depending on your Honour's view of the proper scope of the expert evidence, that may be faster, maybe rather lengthy. But I would still imagine, and I don't know whether my friend agrees, that we would be on track to try to get to the end of the evidence tomorrow. It's not impossible, but one best laid plans and we're out.
Well, I would encourage people to recognise that a lot of the expert evidence is dependent upon the findings of fact. There's not much point in cross-examining an expert along the lines of, but if the fact is otherwise, then the result is otherwise, isn't it?
Yeah. Quite.
Nonetheless, we're going to miss out on at least some time tomorrow on Wednesday afternoon. So
yeah.
it seems to be wise if we do start a bit early and try and get as much time under our sleeve as possible and under our belts as possible tomorrow, and try and make sure we do finish with the witnesses. Now, that would leave effectively Wednesday morning and maybe a bit of the afternoon for submissions, and submissions I would have thought here are going to be fairly detailed.
I'm keen to get to the end of submissions by the end of Wednesday. The reason being that the summer is about to intervene, and it's going to, I suspect, and I'm sure many of us have things to do before then subsequently taking some sort of break, and so it's going to be difficult to programme in written submissions, I think.
Well, I would be keen to do it while everything's in our minds also. There is a possibility that of Thursday being available. How are you both on for if we had to go into Thursday? Mr. Francis presumably is here and subject to other commitments could make it. What about you?
I do have other commitments. The question is whether they can be moved, and I can make inquiries about that. I know my instructing solicitor can't be here on Thursday. That may, I don't think that will necessarily get in the way, but I can certainly make inquiries as to whether I can be available on Thursday. At the moment, my flights are due back on the Thursday.
So am I at the moment.
Yeah, and they can be
So
changed, of course. No, absolutely. I have a difficulty. I have something immovable on the Monday, and it's not work related. It's hospital visit, unfortunately. I can't avoid that. So things back up to then, unfortunately.
Well, could I ask you do all to think about the prospect, if we need to, of going into Thursday?
Yes.
Which would be, if it can be done, it would be the lesser of the various evils.
Yeah.
But we'll also, I think, start at 9:30 tomorrow and continue much as we have today. We're going to try and make sure we deal with the difference.
So,
anything else to raise before we go?
Not from our side, John.
not from me.
I'll see you all at 9:30. I'll adjourn until then.
All right.